pursuant to the order of reference on October 1st. The committee is meeting to continue its study on Bill C-9, an act to amend the criminal code, hate propaganda, hate crime, and access to religious or cultural practices. Welcome our witnesses from the first panel. We have one in person, the rest are online. With us in person from the Association Canadienne des Libertés Civiles, Anaïs Bussière-McNichol.
Canadian Civil Liberties Association, Anaïs Bussière-McDonald. Ryan Alford as an individual professor. Bruce Paddy, Professor of Law at the University of Queen's University. Nuzarem Al-Azem, National Council of Canadian Muslims.
At most 5 minutes. I'll leave some flexibility at the end if you're finishing your thoughts, but otherwise I might have to cut you off. But please try to stay to that 5-minute window. We'll start in order. We'll start with Ms. Bussière, who is here in person, and then we will go online and receive the testimony from Professor Alford, Professor Pardy, and then Ms. Al-Azem. So, à vous, Madame Bussière.
Merci beaucoup. Bon après-midi aux distingués membres du comité.
Thank you, distinguished members of the committee. Thank you for the opportunity to share the perspective of the Canadian Civil Liberties Association on Bill C-9. The CCLA is an independent, non-governmental, non-partisan national organization founded in 1964 with a mandate to defend and promote civil liberties, human rights, and democratic freedoms of all peoples across Canada. The CCLA recognizes that while freedom of expression and peaceful assembly are essential to a democracy, they are not absolute and must sometimes be balanced against other rights and interests. These include public safety and the right to practice one's religion in safety, considerations that are already largely protected by the Canadian Criminal Code. However, criminal law is not the solution to all social challenges. On the 6th of October, 37 civil society organizations representing members of the Black, Arab, Muslim, Jewish, and 2 LGBTQI communities, labor organizations, environmental activists, and civil liberties groups signed a joint letter urging the federal government to set aside Bill C-9. A copy of this letter was sent to committee members, and it's also in the annex of the CCLA brief given to the clerk. The CCLA is here today to urge you to vote against Bill C-9 for 5 main reasons. Firstly, this bill removes the long-standing requirement to obtain the consent of the Attorney General before prosecuting on hate speech charges. The removal of this safeguard eliminates an essential institutional control designed to promote an informed and proportionate legal assessment before prosecutions are brought in areas where freedom of expression and freedom of conscience are at stake. The requirement to obtain the consent of the Attorney General is also absent from the new offenses introduced in Bill C-9, despite the obvious risk that these new provisions will affect freedoms of conscience, expression, and peaceful assembly. We urge Parliament not to go down this road. There is simply no advantage in letting the police lay charges that the Attorney General would not have pursued in the first place. Secondly, the new offense of intimidation requires proof of an intent to cause a state of fear in another person in order to impede their access to one of the tens of thousands of civic institutions linked to an identifiable group in Canada. The difference between intending through a demonstration to express unpopular or disturbing opinions and intending to provoke a state of fear is blurred. The Criminal Code already prohibits, among other things, participating in a riot using violence, physically blocking access to property, uttering threats, inciting violence against an identifiable group, forcing people to refrain from exercising a right, and harassing people by causing them to reasonably fear for their safety. The question, therefore, is to know what additional conduct will now be prohibited. Will the criterion be met when a demonstration is particularly noisy, when hundreds of people gather in a public space, when some demonstrators chant slogans that, while offensive, do not constitute hate propaganda? These disruptive elements could be seen by some as evidence of an intention to create a state of fear. Yet these examples are forms of nonviolent expression and peaceful assembly protected by the Charter. They should not be criminalized in a democracy. Thirdly, the new provision on preventing or obstructing access to a building is clearly repetitive of existing criminal code provisions and should therefore not be adopted. Fourthly, the new prohibition on willfully promoting hatred through the public display of certain symbols related to terrorism or hatred is at best repetitive of existing criminal code provisions. At worst, this section opens the door to arbitrary application by police officers, which risk stigmatizing and criminalizing certain peaceful demonstrators. Fifthly, the new hate crime offense requires the police at the outset of the judicial process and without prior review by the Attorney General to make a determination of the motives of an accused. Maintaining the current practice of considering hate as an aggravating factor in sentencing avoids imposing a social stigma on an accused who is presumed innocent and may well turn out to be so. Furthermore, by severely increasing the penalties for hate motivation without modifying the parameters already set out in the criminal code, C9 runs the risk of imposing excessive and disproportionate penalties. Finally, if Parliament decides to codify definition of hate, despite the few legal advantages it will bring, the proposed definition will have to be amended to adopt word for word that of the Supreme Court of Canada. The definition proposed in Bill C9 could be interpreted as lowering the threshold set by the highest court of the land. Thank you for your attention. I look forward to answering your questions.
Professor Alford, 5 minutes.
Thank you very much, distinguished members of the committee and guests. Ryan Alford, I'm a professor at the Boer-Alaskan Faculty of Law. I have taught as a tenured professor of constitutional law for over 10 years, the provisions related to freedom of expression. And I just begin by saying, I can follow up from the previous speaker by saying that, in my opinion, which is my expert opinion, indeed, this bill does lower the threshold below what is constitutional for a limitation on the right to freedom of expression. But just because some people will perhaps think those who can't do teach and kind of assess my testimony on that basis, I would also point out that I've been before a parliamentary committee only once before, and that was in 2017. And in that testimony, I told that parliamentary committee that a provision of a federal bill, which suddenly became a federal statute, was unconstitutional and would be struck down. It was in fact struck down in 2023 in an application which was brought by me. And that appeal, the appeal of that judgment ultimately will be decided by the Supreme Court of Canada, and that appeal will be heard in 2 weeks. So just to tell you why I have some issues with the wording, in particular of Section 319 sub 7, as proposed by Bill C9, I'd just like to begin by talking about the charter statement. So the charter statement, to me, is quite problematic. Just on its face, I would note that this is being produced as an anonymous statement by someone in the Department of Justice, which reports, in this case, to the sponsoring minister of the bill. So there's some kind of a perception here that there's a conflict in the background. And I think it's borne out by the fact that the charter statement really doesn't have any legal analysis of the pertinent issue in it. It's purely conclusory. So let's take a look at the relevant section here. It says the proposed definition of hatred has the potential to engage freedom of expression in Section 2B of the Charter. That's completely insufficient because it is an infringement of the right to freedom of expression. There's no debate about that. The question is whether or not this is a reasonable limitation on freedom of expression, right? That's the pertinent issue here. So it says, this is simply a codification. The proposed amendment would thus codify a definition settled in the leading jurisprudence of the Supreme Court of Canada. Now, as I said in my speaker notes, this is really drawing upon the imprimatur of the Supreme Court of Canada to suggest that this bill is constitutional. Whereas when you actually look, and this is also present in the preliminary legislative statement about Bill C9, that it's really quite different. The Supreme Court, particularly in Whatcott, proposed something quite different. And I'll say, I think this preliminary legislative summary produced by the Library of Parliament is quite good. It does have a good discussion of Whatcott. It just doesn't line up that definition in Whatcott against what's proposed in Clause 4 of Bill C9, which creates the new Section 319 sub 7. So just to look at what's in Whatcott, and this is reflected in the legislative summary, this is the language from the majority opinion penned by Justice Rothstein in 2013 in Whatcott. In my view, expression that, quote, ridicules, belittles, or otherwise affronts the dignity of, end quote, does not rise to the level of ardent and extreme feelings that were found essential to the constitutionality of Section 13 sub 1 of the Canadian Human Rights Act in Taylor. Those words are not synonymous with hatred or contempt, right? So for it to be a reasonable limitation, the definition of hatred has to exclude not merely what it excludes now, but in particular, speech that otherwise affronts the dignity of persons or groups. And that's not what's currently in 319.7. Therefore, it is not a codification of the pertinent leading case that comprises what the Supreme Court of Canada has said is necessary for a reasonable limitation to be constitutional under Section 2B of the Charter. This is a very serious issue and it needs to be addressed. I'm just saying this. This is just one point to be made about its constitutionality in addition to others. I would just direct you not only to what was said previously by Ms. McNichol, but what's going to be said by Mark Sandler in the next session, where he points to the fact that you have, instead of the language which is found in Whatcott or Keegstra, which talks about vilification or detestation, right? That's what the language says in the bill now, that the relevant jurisprudence says, and it is necessary that it both vilify and be detestation. So I'm not going to step on Mark Sandler's toes and deal with that in any detail, but I'm just saying there's a number of constitutional infirmities with the definition of hatred, in addition to other parts of this bill. It's going to lead towards policy problems. I don't understand. So people might say this is a paraphrase. Why are you paraphrasing rather than just putting in that language from the Supreme Court, except if not to create that gap, except if not to say that this is constitutional, when in fact it is not. And there's going to be serious consequences for this. We see in the United Kingdom.
You're at your 5 minutes. Would you just please briefly wrap up? Thanks.
Yes, just in 30 seconds, Mr. Miller. I would say that in the United Kingdom right now, there are 30 arrests per day for what is on social media. And most of it comes precisely in that area of speech that is an affront to the dignity of individuals, but is not detestation and vilification. So unless we're trying to create the kind of regime that exists in the United Kingdom that permits those kinds of arrests, I suggest that we really need to revisit that language of 319(7). Thank you, Mr. Miller.
I think we'll have a chance to examine your thinking in detail in the next hour and a half as well. So apologies for cutting you off. We just have to stick to the 5-minute plan. Professor Party, over to you.
Thank you, Mr. Chair. I do agree with the comments of the previous two speakers. In February 2022, the Globe and Mail published a column with the title, "It's Time to Stop the Sedition by Enforcing the Law and Following the Money." It said, people have been terrorized for over a week. Seditionists and terrorists. Who is the author talking about? February 2022. Yes, of course, the truckers. No violence, no weapons, no assaults, no storming of Parliament, parking violations, road hockey, dancing in the snow, unkind words about the government, seditionists and terrorists. Who is the author of this column? Can you guess? One, Mark Carney, now the Prime Minister. In 1992, American political theorist Samuel Francis coined the term anarcho-tyranny. Anarcho-tyranny, he said, is a kind of government dysfunction. The dysfunction occurs when a government is simultaneously unable or unwilling to deal with serious crime, leading to a kind of anarchy, while at the same time being ruthlessly oppressive in punishing minor transgressions of law-abiding people. The government allows violence, theft, political corruption, and foreign interference, while it is obsessed with controlling what ordinary people say and think and feel. In Bill C, the government seeks to criminalize an emotion. Hatred means the emotion that involves detestation or vilification, that is stronger than disdain or dislike. It is criminal to detest, but legal to dislike. But to detest, of course, means to intensely dislike. That's the meaning of the word. So it will be legal to dislike, but criminal to intensely dislike. Now, where is the line between dislike and intensely dislike? Of course, nobody knows that. The line will be drawn wherever the authorities want it to be drawn, to punish speech that the government hates. Bill C-9 also criminalizes protests that, quote, provoke a state of fear. Not the fear of violence. We have offenses for that already. No. C-9 will prohibit protests that provoke a state of fear of offensive ideas. That is what the truckers were accused of. That's why Mark Carney described them as seditionists and terrorists. Bill C-9 will be used to prohibit peaceful protest, like the truckers, that the government hates. In a free country, and I mean in a genuinely free country, which we once claimed to be, you are allowed to hate other people. And you are allowed to say that you do. Thank you very much.
Professor Party, Ms. Alazem.
Thank you, Mr. Chair and members of the committee. My name is Nuseba Alazem, and I serve as the legal director for the National Council of Canadian Muslims. For over 2 decades, Muslim Canadians have watched as laws written in the name of public safety have crept quietly into the corners of our lives, into our mosques, our charities, our border crossings, and sometimes even into the classroom. And to be clear, public safety never seemed to apply to our communities. To my knowledge, no law was changed after the Quebec City Mosque massacre, when a gunman opened fire on a congregation, leaving 17 children fatherless. To my knowledge, no law was changed after members of my own local community, our London family, were massacred by an Islamophobe who took 3 generations with his vehicle in an instant. There have been more Muslims killed in hate-motivated murder than any other community in this nation. We as Muslims know what the cost of hate is. But were Canadian Muslims consulted about the full contents of this bill? Sadly, the answer is a stark no. We're here today because this bill ostensibly attempts to take a stand against hate, but in its reach, it risks blurring the line between fighting hate and legitimate free speech. So let me begin with what works in the bill. The new hate-motivated offense provision, section 320.1001, is something NCCM supports generally. In fact, this was a clear recommendation after the London terror attack by the Canadian Muslim community to legislate a standalone hate crime provision. That said, the bill has many shortcomings that are alarming for our organization. Much of this bill looks like attacking the freedom of the 64% of Canadians who believe that Israel has committed a genocide in Gaza and have taken to the streets over the last 2 years to protest Canada's complicity. In practice, it will end up impacting every Canadian. Section 2.2 sub C, the clause criminalizing symbols resembling those set out in that section, is particularly concerning. Now, on paper, the language within that clause may sound tidy. In practice, it's dangerous, because who decides what nearly resembles means? Who decides what confusion looks like? Let me tell you what that looks like from our side of it. It looks like a student flying a black flag with a simple declaration for Muslims and someone calling 911. It looks like police officer unsure that this flag might resemble something on a watch list, because to be organizations like ISIS had it in their imagery, in our sacred texts. It looks like police receiving a phone call that a protester is wielding a terrorist flag, when in fact the flag in question is the national flag of the state of Palestine, a state recognized by Canada. That's a true story, by the way. But because we didn't have a law like this on the books, the individual was merely detained at that time. With a law like this, that person would likely have been charged. And suddenly, the burden of proof doesn't fall on the person making the accusation. It falls on the Muslim or Palestinian advocate who dared to be visible, as long as the officer is confused and thinks that they're trying to cause fear, including online. This clause would criminalize confusion. And this also means that things like the KKK hood remain entirely legal, as the KKK is not a listed terrorist entity. We agree with those on this committee, including the Conservative members, who have said that these kinds of provisions are fundamentally dangerous. It is an undue restriction on free speech. Say, for instance, that a Canadian wanted to suggest that a certain policy is oppressive by comparing it to a policy of the Taliban and wanted to make a visual representation of that using symbols on their Twitter account. Suddenly, they're at risk of being charged. That is what is at stake here. And really, we've been here before. After 9/11, entire communities were surveilled in the name of security. Muslim charities were audited into oblivion. Families lost livelihoods. Mosques were raided. Children watched their parents humiliated at airports, all because fear had been legislated. Each time it begins the same way, with language that seemed small, almost reasonable. Each time it was said that this law was only about them, about the extremists, the dangerous few. But the line between them and us has always been easier to move than to defend. And when the state starts legislating resemblance, when it criminalizes looking like or sounding like, it's no longer protecting Canadians. So here's what we're asking this committee to do. 1, strike section 2.2c, remove the nearly resembles language entirely. 2, halt the passage of this bill until true consultation can take place with communities that have been actually massacred by hate. And 3, expand funding for education and prevention programs that counter hate before it becomes violent. Let's make sure that the next generation learns that safety doesn't come from censorship, but from understanding. Thank you very much.
Thank you, Ms. Alazem, and indeed all the witnesses for their succinct presentations. People are familiar with how these rounds work. First round is 6 minutes per MP, and then the second round, we'll get into probably a third round, given that we are going to, we're going to 5 o'clock on this set of witnesses. So we'll probably get deep into the third round. So we have MP Lawton going first for 6 minutes. Ensuite, la députée Dillon. Ensuite, le député Fortin, 6 minutes chaque. Deuxième tour, M. Baber, 5 minutes. Chang, 5 minutes. Fortin, 2 minutes et demie. Gunn et Housefather avec 5 minutes chaque. Donc, je commence avec le député Lawton. Andrew.
Thank you to all the witnesses for your time and analysis on this. I'd like to start with you, Professor Party, and because you're joining us virtually, you didn't have the privilege of seeing the Liberal members of this committee snickering as you were talking about the Liberal government's assaults on civil liberties in the past. But I think that is important context for what we're seeing here, because in your opinion, these are not benign provisions. These are significant expansions of the power of the state to regulate thoughts and emotions and expressions, correct?
Correct, yes.
So when you look at language, and I'll ask you this as well after Professor Alford, but first, Professor Party, in your analysis of legislation in the past and your knowledge of statutes, when words are omitted from jurisprudence, that is not what codification of jurisprudence is, correct?
Correct, yes.
So explain in practice, if you are a police officer that is doing an investigation or you are a judge weighing in on this, how significant is the omission of the words extreme manifestation from the definition of hate that exists in the common law now to the one that C9 puts in law in the criminal code?
Yes, so thank you for the question. And this is really Professor Alford's point. You have a common law, you have a jurisprudential context. The Supreme Court of Canada in the 2012 case of Whatcott describing what was a reasonable limit on freedom of expression. And let's just underline this. They said that this was a reasonable limit, but they also said that this is an infringement of freedom of speech. So what you have to start with in C9 is an infringement of freedom of speech. This definition does infringe freedom of speech. That's what the Supreme Court says. Okay, so this is an infringement from a government that claims to be a government of the Charter and of rights. So we start there, and then if you fiddle with the wording, if you leave words out, if you make it detestation or vilification and not and, for example, then you are downgrading the threshold above which you need to get in order to find that this is established. Right? So it's a little bit of playing around with the words so as to appear as though you're doing exactly what the Supreme Court said, while you're not really doing that at all.
And I'll go to you on this, Professor Alford. I believe you did review the Minister of Justice's testimony on Bill C-9, and in that he said, and I'll quote directly from what the minister remarked here. He was asked about the definition. He said, "This was not an attempt to dilute the definition. It was an attempt to make good on the spirit of that definition and provide clarity to law enforcement." What is your view on the minister's characterization of his own bill, Professor Alford?
It's incorrect. And I would say that the problem is that the courts are going to look at the decision to use this particular language that omits the language from Whatcott that I cited in my testimony and say, well, that's clearly an intentional decision. You made the decision, seeing what was written in Whatcott, to leave this out. Now, the most ominous possibility here is what's going on behind the scenes, is that the government is actually seeking a ruling from the Supreme Court in due course that would lower the threshold to what they're putting forward in this bill. They're saying, well, you said that in 2013. If you uphold what we wrote into this bill, which intentionally left out some of the language that Justice Rothstein, since retired from the court, of course, included in that judgment, that you will then say that this is a reasonable limitation on freedom of speech. And I think that's particularly dangerous.
Explain to me, if you could, Professor, and I realize that hate is inherently subjective, which is the problem that we've been identifying with this, but what would the practical application be in your view? What would be captured by this new definition that isn't captured under the existing definition, just to demonstrate how this dilution and this lowering of threshold is actually happening? Or is there no way to make such a prediction right now?
Well, I think there is, Mr. Lawton. I would just say, if you look at what's happening in the United Kingdom right now, where, now remember, there's no entrenched right to freedom of expression in the United Kingdom. They don't have anything like the Charter, which creates that right. So there you have speech that purportedly abrogates the dignity of individuals or groups. That's the basis for complaints to the police, and arrests are being made on that basis. Now, that's what the language from Whatcott that is left out in the proposed definition of 319 sub 7 would allow, precisely that, people to make complaints that what someone's saying is hatred. And the reason why it's hatred is because it's an intentional attempt to infringe their dignity as an individual or members of a protected group. So we've seen quite a lot of this in the United Kingdom, particularly with very charged issues such as competing rights around what's called gender identity issues and women's rights, where you've had many people who felt like they were engaging in good faith, who are now the subject of visits from the police and then arrests because of the complaint that what they've said and the way that they've engaged on this issue is engaging and detrimental to the dignity of the people with whom they engage.
It's a valid point, Professor, and I know that Minister Fraser had mentioned to my colleague, Mr. Baber, that it was, quote, far-fetched to imagine UK-style tweet policing in Canada, and then moments later, he admitted that Bill C-9 will cover what people say on the internet. So very quickly, is that a legitimate concern for Canadians if C-9 passes, Professor?
It's eminently legitimate, Mr. Lawton.
Thank you.
MP Dillon, over to you.
Thank you, Chair. We're going to start with Professor Alford. With police reporting over 2,200 crimes already this year, do you agree that Parliament has some duty to ensure the safety of people and to ensure that there is peace in our society?
Well, there's a hierarchy of responsibilities for the government. I would say that, generally speaking, when people talk about a rule of law state, they talk about a constitutional state in which the primary responsibility of the government is to observe the constitutional limits for anything that it might want to do. I mean, it would be really easy to address crime by rounding up suspects and executing them without trial, but we can't do that within our constitutional state because of the existing constitutional limitations. And observing those limits is deemed to be of higher importance than addressing any problem, however pressing.
And you spoke about the possibility of parts of it being struck down, the bill, and that in the past you had testified and something like that had occurred. what would you propose we do as parliamentarians, as people who are here to protect society, to make laws? What do you suggest with all the
Well,
hate and the violence that's taking place these days?
My suggestion is that when you want to create legislation, you have to understand that it's only going to stand if it's indeed constitutional. There's no purpose in passing legislation that as soon as it encounters a constitutional challenge is going to be struck down. So you have to, if you want to address this issue of hate, craft legislation that conforms to the existing limitations in the jurisprudence of the Supreme Court of Canada. So in this case, I would just say, at minimum, you've got to go back to the definitions in the bill, particularly those found in Section 319 sub 7, as proposed by Clause 4, and have it reflect quite accurately what is said in the leading cases of the Court of Canada, particularly Whatcott, as myself and Professor Party have highlighted.
Thank you so much. My next question will be for Ms. Al-Azam. We've seen a rise in, hate-motivated threats and vandalism against mosques and other cultural centers and synagogues and other religious institutions. How meaningful is this legislation for those communities who simply want to gather and worship in peace?
I very much appreciate your question. I think, again, I can understand that the ambition behind this legislation may be very noble in attempting to address hate, but if you do it to Professor Alford's point, if you do it in a way that's going to go beyond what you're setting out and going to infringe upon people's free speech rights, that really is a huge concern for all community members, including the community members that we're purporting to protect. And I maybe would just also note that as far as the Muslim community goes, a lot of I see day in and day out the cases that come across my desk. Just this past week, right, a violent assault on a Muslim woman in Toronto, viciously beat on the streets of Toronto. Unfortunately, those kind of obstruction provisions really don't address a lot of the real life cases that I get that come across my desk. So I think this is where it's really important to go back, have meaningful consultation, and make sure that we strike the right balance and get the right type of legislation moved forward.
It's all about balance, but what if these consultations took place? Would you do differently? Would you suggest differently?
Oh, for instance, the 2.2 sub C, right? The concerns there about confusion and resemblance, certainly that should not make its way forward. You can't even train your way out of something like that. You can't train law enforcement out of something that is ambiguous in the way that it's even defined, right? To effectively criminalize confusion. So I would start off by removing those very, very obvious concerning portions, having real consultations with civil society community members, looking at whether that means looking at the definition, making sure that we get that right balance, and then making sure that what we're proposing actually addresses the real causes that we're seeing of hatred, and don't unduly restrict people's legitimate rights, as the CCLA pointed out earlier, right? Legitimate rights to free speech, free expression, and free assembly.
Thank you so much. I don't have any other questions. Thank you.
Thank you. Monsieur Fortin.
Merci, Monsieur le Président.
Thank you, Chair. Thank you, Madame Boussière, and the other witnesses for being here with us. My first question goes to Madame Al-Azam. I would like to know what she thinks about religious exception. A bill was tabled to make sure that we withdraw from the criminal code the two provisions defending 319, where you prevent people from promoting anti-Semitism. Do you think that this exception should remain if it is withdrawn from the code?
Thank you very much for your question. If I understand it correctly, I think you were asking about the defenses for these types of hate-related issues, and I really appreciate your question because I didn't get the opportunity to get into some of my concerns around the defense set out here, for example, in this bill, which includes, I believe, the defense says if the display of the symbol is for a legitimate purpose, including a legitimate purpose related to journalism, religion, education, or art, that's not contrary to the public interest.
Seulement au sujet de l'exception.
Only religious exceptions for now. 319 of the Criminal Code. Are you familiar with that section of the Criminal Code, 319?
Yes.
Donc, OK, vous savez de quoi je parle.
So you know what I'm talking about. I would like to have your opinion. We don't have enough time. What do you think about the idea of removing those defenses from the Criminal Code? Is it a good idea or a bad idea?
I think I'm certainly not going to be able to have enough time to be able to flesh out my points in the time that I believe I have left. But in terms of defenses generally, I do think that they need revisiting. I think that the part about whether it's contrary to public interest may address your concerns that I think you're trying to raise. But I would just further state that there isn't a defense against for academic interests, and there's no defense for political speech, for example, or protest.
Je m'excuse, Madame Alazem, je ne veux pas être impoli, mais on n'a pas beaucoup de temps. Je vous remercie.
Thank you. I don't want to be impolite. I don't have enough time. Alid Shakawi made a public declaration in Montreal in 2024, last summer, in October 2024. He was saying that Allah, take care of the aggressors, take care of the enemies of Gaza. Allah, count them all and exterminate them, spare none of them. End of quote. I would like to know what you think of this declaration, Ms. Al-Azam. Are these the types of declarations we should allow here in Canada?
Sorry, I didn't quite hear the end because of the translation. Could you just repeat that?
Oui, je peux le répéter, mais...
I may repeat, but time is going fast. Let me repeat. Allah, take care of these Zionist aggressors. Take care of these enemies of the people of Gaza. Allah, count them all and exterminate them. Spare none of them. That was a declaration made by Mr. Adi Chakawi in October 2024. My question is to find out what you think. Should this type of declarations be allowed in public spaces here in Canada?
I think that I don't think that I think if I'm trying to understand what you're saying, I believe that the public interest piece does address what you're saying. Do I think that religious texts should be criminalized? No, I think that's what you're trying to get at.
Vous pensez pas que ça devrait être criminel? Vous pensez que ça devrait être autorisé?
You don't think it should be criminalized? It should be authorized?
I don't believe that religious texts, including the Bible and the Torah and the Quran, should be criminalized. No.
Mais là, je vous demande pas si la Bible est criminelle. Je vous demande...
I'm not asking you whether the Bible is criminalized. I'm talking about a statement that was made by someone. Do you think it's an acceptable declaration to be made in a public space in Canada?
Right. I'm actually not familiar with that statement or the context around that statement, so I'd prefer to be able to...
Madame Al-Azem.
Thank you, Madame Al-Azem. I'm sorry, but my time is going by. Madame Bossier, you heard my question. I would like to find out what you think about that.
Je vais faire un pas en arrière.
I'll step back a bit. I heard your question concerning religious exception. That's an exception that only applies for the offense of promoting hatred. There's one for hatred and another one for anti-Semitism. There's a specific definition of anti-Semitism. But should those defenses be legitimate or should they be removed from the criminal code? Could you please stop speaking because it's interfering with our discussions? Madame Bossier, you have the floor. What I was trying to say is that there's public speech that could incite violence against an identifiable group already criminalized. We know those rules. My question is, in your opinion, should those defenses be withdrawn or not from the criminal code? The criminal code, as it stands now, talks about promoting incitement to hatred. Well, I don't really have enough time. Yes or no? Should it be withdrawn? In a context where people are willfully promoting hatred, we could refer to the definition provided by the Supreme Court and questioned in C-19. We do not support withdrawing those defenses. Thank you. The statement I read out concerning Shakawi, is it acceptable or not in public spaces in Canada? It all depends on the context. I do not see why it should not fall under other categories. Mr. Chair, there's crosstalk. It's difficult for the interpreter to interpret.
Monsieur Fortin?
Je pense que ça pourrait tomber, selon le contexte, sous le coup de d'autres accusations
C'est
criminelles.
complet? Non, plus que 5 minutes.
De traduction me font perdre du temps.
Because of translation and interpretation, I'm losing time. People were speaking in the room, and my time was wasted. You must also allow people complete their sentences.
Keep it quiet or go outside and continue the conversation. Thank you. Over to where we at? Mr. Baber for 5 minutes.
Thank you. Ms. Alazim, you're Director of Legal Affairs for the National Council of Canadian Muslims. Is that correct?
That's correct.
I want to talk to you about Section 319. Do you know what the phrase intifada means?
Yes.
What does it mean?
Intifada means is a form of revolution.
It's a violent resistance, correct?
There are a number of different intifadas. There was a bread intifada in Egypt that came in. It was about economic
revolution. In the context of intifada against Jews in the state of Israel, intifada is violent resistance. Are you going to suggest that it doesn't involve violence?
I think it can involve violence, but I think it can also not involve. Are we really having a discussion about Arabic translation right now?
I appreciate.
I speak Arabic. Do you speak Arabic?
I speak a little bit of Arabic. So
okay.
I thank you for conceding that in that context it involves violence. So now the term intifada is shouted every day on Canada's streets, whether it's Viva Viva Intifada or Globalize the Intifada, which means bring the Intifada here to Canada. So in your view, when that is being chanted in a North York neighborhood, is that incitement to violence or not?
Let me be clear. This has always been the case of the position of the National Council of Canadian Muslims. If anybody is espousing any form of hatred against any group, and that includes anti-Semitism, Islamophobia, any other group against an identifiable group, that is incorrect.
I'm talking about the second section in 319. I'm not talking about hatred. I'm talking about incitement to violence, which is the other section. So my question to you again, if you already concede that this is violence and it is shouted on Canadian streets, do you agree with me that the chant globalize the Intifada or Viva Intifada is incitement to violence, yes or no?
I think that your question actually really belies a lot of the problems with bringing this bill forward, and I think it belies some of let's say, motivations behind bringing it at this point. I think Professor Party was referring to the convoy. We saw a number of hate slogans and hateful logos and symbols around the convoy. We saw a number of them.
Okay,
there was no attempt to bring a bill like this forward. So I think, if anything, your question is actually belying that this is meant in order to curb the civil liberties of the millions of Canadians who have taken to the streets peacefully to oppose genocide.
I'm perplexed that a Canadian lawyer somehow could justify incitement to violence. I'm also a lawyer, and I'm very perplexed by your position. Hamas is a listed terrorist entity in Canada. Do you think it should be legal to fly a Hamas flag on a Canadian street?
To be clear, this bill goes much beyond that. And
just answer my question, please. I'm not asking beyond. I'm just asking about the flag. Should it be lawful? Should it be lawful to fly Hamas flag in North York?
I think that it really depends on a lot of different things. What's the intention of the person flying it? And again, this is why something of this nature that impacts civil liberties does need to be examined very clearly. And I'd just like to say that I did not concede that Intifada is violent. I specifically did not concede that.
All right. And if a person is chanting Intifada and they're holding a flag of a terrorist entity like Hezbollah, should that be criminalized in your view or not?
Again, my view is that this bill it's not even scratching that surface, because let me give you an example of what we've seen and my concern for this bill. Over the last year, we've seen Shia, members of the Muslim Shia community every year take to a procession, right? It's called the Arba'in, and they take to the streets. They took to the streets in Montreal wearing a green headband with Arabic calligraphy on it.
I wasn't asking about symbols. I'm sorry, my time is short. I only have about 30 seconds. I refer you to the NCCM statement of October 8th in response to October 7th. Why did the NCCM statement of October 8th fail to mention the word Hamas? A day after the October 7th attack, why did your organization, in the statement that it issued, why did it not mention the word Hamas once?
I don't know how that's even relevant to the provisions that we're discussing here.
Why did your statement fail to condemn the October 7th attack?
So what? So sorry, listen, with all due respect, I think that my community has overseen the largest attacks of deadly attacks against an identifiable group in the G7 under in the past few years, and I think that, and I've had to attend the burial of my community members.
Do you condemn the October 7th attack?
The political class has allowed to fester, in part because of a lot of the rhetoric.
Do you condemn the October 7th attack by Hamas? Do you condemn it?
Do you condemn Israeli genocide?
I'm asking the question.
I condemn the death of any innocent life. Do you?
Thank you, Ms. Alazem. Thank you, Mr. Weber. Now over to MP Chang.
Professor Party, as the first openly gay member of this House, I'm very proud of my own identity. In 2008, when I studied in Australia, somebody shouted at me, told me to go back to Asia when I walk on the street. And more recently, in 2022, at Metrotown Station, one of the busiest SkyTrain stations in Vancouver, someone shouted at me and said, "What are you looking at, Asian? If you want to F-word, go to Davie Street. You say it is okay to hate people in this country. Do you agree what I was told is appropriate?"
Oh, I think it's very inappropriate. But that's not the question. The question is, should it be illegal? It's definitely inappropriate, but it should not be illegal. If people want to say stupid things and let everybody know that they're stupid people.
Thank you. So Canada's charter protects freedom of expression, but it also protects safety and dignity of every person. So do you believe it's ever acceptable in a democratic country to justify hate toward others using disguise of free speech?
It's not a disguise. So earlier, Ms. Dillon basically asked, well, what are we supposed to do otherwise? And the answer to that is, you're supposed to prosecute violence. Violence is supposed to be criminal. And the failures that we're experiencing is because violence is not being properly prosecuted and punished. Violence is the line. It's not language.
Okay, thank you. Thank you. So everyone agrees that hate-motivated violence has no place in Canada. Would you agree that the government has a responsibility to ensure that Canadians live and can live and worship safely, free from fear?
Free from violence, yes, free from violence. If you fear violence because of the threat of violence, then that should be criminal. Yes, the assault, which is a threat of violence, is criminal already. It's nothing to do with C9. We already have provisions in the criminal code that prohibit violence and the threat of violence. That is appropriate. We're not talking about that. We are talking about trying to keep people safe from some other boogeyman when violence is absent, and that is the mistake.
Thank you. So my next question goes to Al-Ziem. Canada prides itself on diversity, inclusion, and freedom of belief. Would you agree that protecting these values require more than words, that it demands action when hate threatens our communities?
Sorry, I think that's directed towards me?
Yeah.
Sure.
Yeah, so...
Sure, yeah.
Okay, so we have seen a troubling rise in hate-motivated threat and vandalism targeting mosques and culture centers. How significant is this legislation for your community?
Thank you for your question. Again, this legislation can be potentially very significant. I do think it's really important that we strike the right balance on it and make sure that we are protecting all minorities, all identifiable people, and all Canadians, really, in a way that does not unduly restrict our civil liberties.
Thank you. And what message does this send when the Parliament stands united against hate while upholding freedom of religion and expression?
I'm sorry, I missed that question.
What message does it send when Parliament stands united against hate while upholding freedom of religion and expression?
Certainly, it sends a very powerful message. It sends an extremely powerful message.
Yeah. Thank you. I have no.
Monsieur Fortin, 2 minutes et demie.
Monsieur, ma question.
Mr. Chair, my question goes to Mr. Alford. Professor Alford, I would like to know, I have 2.5 minutes, so it's going to be fast. If you don't want to respond, we can move on to something else. I will ask you the same question that I asked Madam Al-Azam a while ago. The religious exception provided for in sections 319, the two religious exceptions to prevent hate and anti-Semitism on the basis of religious text, should those exceptions be withdrawn from the criminal code or should they be maintained?
I believe they should be maintained. And my reason for saying that is I think that if prosecutions were initiated on the basis of religious speech, it might very well infringe the guarantees of religious freedom and the Charter.
Merci. Monsieur Alford, deuxième question que j'avais posée.
Thank you. I asked a question a while ago. The statement made by Adil Shakawi in October 2024 in Montreal, and I quote, Allah deal with these Zionist aggressors. Allah deal with the enemies of Gaza. Allah count them all and exterminate them, spare none of them. In your opinion, can that statement incite hatred, and should it be allowed on Canadian soil?
I think it's certainly capable of inciting hatred. I'm not positive that you can restrict the speech phrased in the form of a prayer without running into the guarantees of the Charter of Freedom of Religion.
Donc, si je comprends bien votre témoignage et corrigez.
If I understand you well, that statement should be allowed depending on the current legislation in force, correct?
I believe under the legislation in force, it would be allowed, and I think that changing that would bring us into some difficult constitutional issues.
Merci, Monsieur Alford.
Thank you, Mr. Alford. I have 30 seconds left. The authorization of the Attorney General to prosecute, in your opinion, is that authorization a good thing? As C-19 proposes, is it okay or preferable for it to be withdrawn, the consent from the Attorney General?
It's a bad idea to take out that requirement that the Attorney General approve these prosecutions because they are so particularly sensitive that there should be some political accountability for authorizing them.
Merci.
Merci, Monsieur Dr. Alford.
Merci, Monsieur Gunn pour 5 minutes, suivi de Monsieur Housefather aussi avec 5 minutes.
Thank you, Mr. Housefather. 5 minutes.
Professor Party, by lowering the threshold for what constitutes hate speech and removal of the requirement for Attorney General consent, do you think it opens the way for potential politically motivated prosecutions?
Yes.
Can you maybe expand on how that might happen?
Well, because you will have a criminal provision that is completely uncertain in its meaning, and the people who are out there on the street will have no conception about where the line is between things that are okay and things that are not. And you don't have a check on political decisions like Professor Alford just alluded to. And so you basically have an open book. You can if you have the political wherewithal, the means to direct certain outcomes, then certain prosecutions, certain initiatives, then of course that's what you will do. And that is a poor way to construct the law. You are asking for trouble instead of trying to design the law so as to prevent the possibility of that kind of outcome.
Professor Party, Bill C-11, Bill C-18, Bill C-63 from the previous Parliament, and now we have C-9. What do you think it is with this Liberal government that's been in power now for over 10 years and their general aversion to free expression and persistent attempts to restrict free speech in Canada?
Well, there does seem to be a determination to make sure that the government is the one supervising people's speech. And I would like to emphasize the distinction that I alluded to earlier, which is that the proper restriction on speech in my books is one that distinguishes between violence and speech that is not violent. So it's perfectly adequate to limit speech by saying you cannot use speech to threaten violence. That makes sense, and we have that in our laws already. We had them for a long time. But all of these legislative initiatives, especially Bill 63, which was, for my money, the worst of the lot, but including C9, is attempting to cross that threshold and say, well, even if violence is not involved, even if you are not threatening violence, you're still not allowed to say certain things because we don't like it. And that's where you get into dangerous territory with freedom of speech. That begins to mean that your guarantee, your constitutional guarantee of free speech is not that at all. You can just compare the Canadian state on this to the situation in the United States. I mean, we both have, in both countries have a constitutional guarantee of free speech. In the United States, the government is not allowed constitutionally to limit speech, which here would be called hate speech. Hate speech is not a thing in the U.S. because the courts have said that is protected speech. And yet we've ended up in a situation here in the legislation that you're alluding to, where the government is trying here and there and everywhere to try and limit how people talk.
Professor, what do you foresee as the worst case scenario of this bill should it pass? What is the slippery slope? Could we see people being arrested for edgy social media posts? Could we see political opponents? I have to bring up this hate speech thing. We have Liberal members of Parliament who have accused Jordan Peterson of hate speech, who have accused the recently assassinated Charlie Kirk of hate speech. Are they not, by making this accusation and then putting forward a bill like C9, essentially calling for their political opponents to be jailed?
Yes, well, potentially. Anyway, I mean, you wouldn't want to make that accusation without some concrete information, but essentially, yes. You could see happening in Canada the kind of thing that has been happening in the UK, where the police are sent out on missions to crack down on people saying, dangerous things online. I mean, that is not the situation you want in a country that claims to be free. You do not want a political role in determining what people can say. And the Jordan Peterson case is an excellent example.
Professor Alford, I have 30 seconds with you. You talked about the potential for this bill to violate the charter and be struck down. I did a documentary on free speech a couple years ago. There was a 5-4 decision that almost basically fined a comedian for telling a joke. How confident are you in the current makeup of Canada's Supreme Court to uphold free expression rights in Canada?
So the Ward decision that you alluded to would have completely changed the framework for the evaluation of reasonable limitations on freedom of speech. It was extremely troubling to see that it was considered a close question by a number of the justices. So I would really have strong fears that were this to come to the Supreme Court of Canada, that they would reevaluate that framework with the idea of balancing freedom of speech against some other compelling objective that would really be fundamentally dangerous to the democratic accountability and legitimacy of the government and indeed our constitutional state.
Thank you. Mr. Housefather, 5 minutes.
Thank you very much, Mr. Chair. I just wanted to jump in and say a couple of things before I ask some questions. The first is that there's been a comment that there wasn't consultation. I know that there has been substantial consultation on this bill that have been done not only by the current minister, but by the previous Minister of Justice. And there have been discussions with faith communities across the country, including the Muslim community. I'm not saying that there is always not sufficient consultation, but there certainly has been consultation. I also have heard the argument about the United States. And of course, the United States, as I'm sure Professor Party would acknowledge, doesn't have Section 1 of their charter that limits freedom of speech in a way that, the right under Section 2 is limited in a way that it wouldn't be in the United States. And I think we would agree on that. I'd also note a comment from some of the Conservatives. I think it's important to remember that this committee last December issued a report in which we recommended the significant majority of the things that are in this bill and the Conservative Party issued a limited dissent, which didn't dissent on any of these points. So I just want to put things into context. Professor Party, you mentioned that people should be allowed to hate and allowed to say that you do hate. And in a way, as long as they don't encourage violence, I guess people can hate. As long as they don't incite, I guess they're allowed to say that they hate. I don't disagree with you. We can morally say that's wrong. For example, one of the things that you once said, Canadians have been sold a bill of goods. Many of them think that they have a right to equal treatment under the law. They think that discrimination is illegal, but nothing could be further from the truth. In Canada, discrimination is lawful as long as it is committed against the right groups, and in particular against straight white men. I think we can both agree that many people might disagree with what you just said there, but I don't know that you would argue that this bill would allow anyone to decide that that would be hate speech, would you? You wouldn't imply that this bill is going so far as to criminalize that type of speech, are you?
I'm sorry, to criminalize what kind of speech?
The speech like you just made, the speech where you declared that, for example, straight white men were the ones that were discriminated against in Canada. That you're not arguing that this type of law would stop you from saying that, are you?
I don't think I would go quite that far. What you're reading from is a legal analysis. So if we get to a place in this country where doing a legal analysis is criminal, then we're in really bad shape. But I wouldn't have jumped to there, no.
Okay. So Professor Alford, can I ask you a question? You had talked, and rightly so, about there's always a balance, right? I agree. The Charter Statement should make clear that this is a clear violation of Section 2. There is no doubt. And the question is whether it's saved under Section 1. And there are restrictions on freedom of speech that can be saved under Section 1, as Keekstra said, as other cases have said. And there must be a limit where, for example, my right to freedom of speech blocks someone else from exercising their right to freedom of speech. For example, if I intimidate or obstruct someone from entering into their place of worship, so they have no longer a right to practice their religion freely, we can't say for sure how a court would rule, but it is a legitimate decision of the legislator to determine that that would be consistent with a Section 1 limitation of Section 2 rights. Would you not agree, Professor Alford?
I do agree. And I would say the reason why I agree is because there we're talking about what are frequently labeled time, place, and manner restrictions that don't talk about the content of the speech. So therefore, it's far more likely to say it's a legitimate restriction because we're not making this discrimination on the kind of speech which is involved. But I think that what you're pointing to is the kind of thing that we should be crafting rather than talking about particular types of speech or the intentions behind speech.
Totally understood, and I appreciate that discussion. I take note of your point under 319 and the definition. Ms. Alazim, I'm going to ask you a completely different type of question, but can I just give you the opportunity, because I don't think you understood the translation of what Mr. Fortin said in French, and I just want to give you the context in English so that you could perhaps answer and put yourself on the record as you want. Maybe you just want to leave what you said, but I'm not sure you would because I'm not sure you understood exactly the translation. What Mr. Fortin was asking, he and the Bloc Québécois have a private member's bill that they have proposed to remove the religious exemption on hate speech. For example, if I make a speech and I can claim that in my good faith my religion led me to this speech that would otherwise be hate speech, then it's okay. So Mr. Fortin was asking you whether you agreed with him that that religious-based exemption should be removed from the bill, which is what he's proposing. That's what he was asking.
Thank you, Mr. Housefather. I appreciate your opportunity to give me an opportunity to clarify. I appreciate the question. There's a few things I want to clarify. So I'll start with
you'll
clarifying.
have to be extremely quick in your response.
For the record, that NCCM has condemned the October 7th attacks. Just to be clear, has condemned the October 7th attacks by Hamas and likewise condemned all violations, really, of international law. But I just also want to note that nobody else was asked these lines of questions on this panel, and it, again, belies that there's real concerns with this type of legislation. And I'm tired, frankly, of our communities being asked this 2.5 years into genocide, that there's always this proximity to terror and hate that's constantly associated to the Muslim community.
Ms. Alazem,
so I just did want to clarify that.
We're way over time. Any clarification you can gladly submit in writing, or someone else on the this team can
Happy
follow
to
up in
do
the next
so.
round of questions. Thank you.
I would also just note I didn't ask those questions.
Thank you, Mr.
I only
Housefather.
asked you to clarify.
Thanks.
Thank you. If we keep this next round tight, we'll get through everyone. Otherwise, it'll cut into Mr. Babber's or Ms. Dillon's time. So let's get going. We're starting off with Mr. Lawton, then Latanzio, Fortin, Babber, and then Dillon. So over to you, Andrew.
Thank you very much. Madame Bussière, I'd like to ask you about C9's approach to hate symbols. Now, you would agree that under the current law, someone who displays a hate symbol, and I'm using broadly the definition, let's say, that C9 uses, could be charged under Section 319 right now, correct?
Effectivement, il y a différentes dispositions du Code criminel qui peuvent être utilisées.
Yes, various provisions of the criminal code could be used when symbols are used. All will depend on the context. One of our questions concerning the provision is to look whether we are already repeating something that already exists in the criminal code.
Believe that as worded now, Bill C9 would make the display of a symbol on its own a criminal offense, or do you believe that it is just part of the context that could lead to a hate charge?
C'est intéressant parce qu'il y a une tension par rapport à ça dans la manière.
It's interesting. The way we read the text may be different from the way the minister has presented it. He said it's not complete prohibition of any display of a symbol. But when we read the text, it's not very clear. We seem to associate the fact that there's a desire to incite hatred and the fact of displaying a terrorist or a symbol of terrorism or hatred. But there are already criminal consequences if symbols of terrorism are displayed or symbols of hate, but all will depend on the context.
You shared that, Madame Bussière, because this is us with the hate definition, another example then of where the minister's description of the law actually differs from the law itself.
Bien, il y a certainement une tension. Après ça, à partir du moment où...
There is some tension, but the courts will have to interpret it, and they will refer to the text, to the context, to the objective of the legislation and the intention of the legislator, what was said and what was presented. So I cannot give you a final answer to the question, but when you read the text, it raises some questions.
Professor Party, I'd like to return to you on this. Are you aware that the Ontario Human Rights Commission views misgendering someone, identifying them as the wrong gender, to be discrimination and to be against the law of the Ontario Human Rights Code?
Yes.
So when we saw Bill C-16 in a previous parliament, this was the bill that led Jordan Peterson to speak out so vocally on this. This was expanding Canadian human rights law to include gender identity and effectively embedding in Canadian human rights law the very similar provisions that we have in various provincial human rights codes, correct?
Correct.
So I realize the Canadian Human Rights Act does not itself tie to the criminal code, but it does give a sense of where the government wants to go with this, especially looking at Bill C-63, the Online Harms Act, from the previous parliament. And do you see misgendering as being something that could attract a hate charge, the way that this government has viewed hate and the way that C-9 is worded?
Certainly. Potentially. Sure. There's no reason to think not.
And that is, to go back to the UK case, precisely what a lot of people are finding themselves receiving the knock on the door from a British constable over. It's them tweeting something that has waged into gender. Now, again, I do not take, in the purpose of our discussion on C9, the view that this committee needs to weigh in on this, but it is a live issue that people should be able to freely debate. So when the state is deciding what constitutes hate, my question is, what are the implications on limiting the ability to hash out controversial subjects in society?
Well, they could be devastating. Yes. So there's a back when C-16 was being debated, I was a witness at one of the Senate committee meetings, and one of the senators in that meeting said to me, "Well, look, I'm a free speech guy, but this requiring people to use proper pronouns is just reasonable speech. It's reasonable speech, and therefore it's reasonable legislation." And that completely misconceives the whole idea. The job of the government is not to legislate reasonable speech. If you had a statute that said Canadians will be required to say hello and please and thank you, because that's reasonable speech, that is totalitarian. because speech is something that people decide for themselves. And so as long as the government thinks that its role is to make sure that people are speaking reasonably, then you're totally off on the wrong track. People's speech is their own unless, for my money, unless they are threatening violence. And if you're over that threshold, you're going to get into the potential for the kinds of problems that you are alluding to. And that potential is very, very real.
Okay. Well, appropriately, thank you. I'll go on to Ms. Latanzi now.
Thank you, Mr. Chair. My question will be for Ms. Alazem. Ms. Alazem, in recent media articles, Stephen Brown, the Chief Executive Officer of the National Council of Canadian Muslims, said being generally supportive of Bill C-9, noting that his organization has lingering concerns, and I'm quoting, over how the law will be applied and whether law enforcement will properly distinguish between what does and does not count as hate symbol. Can you explain to us what is the scope of hate crime affecting the Muslim community in Canada, and to what extent is it linked to Islamophobia?
Well, it's certainly linked, and the scope is such that I didn't even know about that public statement, because every day I'm busy kind of dealing with the calls that we get day in and day out of Muslims across this country who have suffered from a variety of hate crimes, including just this week, 2 assaults, again, a woman brutally beat on the streets of Toronto. So certainly we see, I think that's what your question was getting at, we see hate crimes of that are unfortunately only gaining in numbers, and they don't seem to be letting up, and in all facets of life. And really, it's as Muslims are just participating in public life, walking down the street, accessing a grocery store, driving out of a parking lot.
How is it, like, if you could explain to us how it is directly linked to Islamophobia?
How those hate crimes are directly linked to Islamophobia?
Yes.
Well, certainly it is. Well, certainly the crimes, I could draw you some direct links of, if somebody's punching you and saying something very, very viscerally anti-Muslim, right, then that's very clear that this culture and climate of Islamophobia enables and emboldens people to be able to behave in that way.
With the legal department, can you give us an idea of how many incidents you've received of this type of hate crime or Islamophobia over the last couple of months, or perhaps the last year?
I think we've received well over 700 in the last year. We do a report annually to, I just don't have the numbers, sorry, off the top of my head. That's something I do go and revisit it annually, but I just don't have it off the top of my head. But I can tell you, I get at least 1 call a day of these types of incidences.
Your opening remarks, you spoke about wanting to be consulted. Were you not aware that, all communities, including the Muslim community, were consulted over the course of the summer with regards to the issue of Bill C-9? Were you not, or maybe your organization, consulted? I just want to be clear on that.
Yeah, to clarify, no, I appreciate the opportunity. To clarify, I said consulted about the full contents. While we were consulted, and we've had many consultations with governments about, for example, the freestanding hate provisions for many years. The parts, for example, about Section 2.2, for example, that's something that was completely a surprise. There's lots of elements of the bill, and that's why I said the full contents of the bill, because it would have been nice, I think, to have proper consultation. 2.2, for example, that's something that was completely a surprise. There's lots of elements of the bill, and that's why I said the full contents of the bill, because it would have been nice, I think, to have proper consultation with all the communities that are impacted, not just by the bill, but that the bill purports to protect.
Parts of the bill were you consulted on during the course of the summer?
I believe it was the freestanding hate crime provision, and perhaps the obstruction offense. To be honest, I wasn't personally consulted, so I'd have to go back and check. It wasn't me that was in those consultations.
Okay, but you do recognize that the Muslim community was consulted?
on certain elements of it, right?
Okay.
But the elements that we weren't are the elements that we take a severe problem with, right? That we have severe concerns.
Which
that we're
is your
raising.
section 2.2.
Exactly.
Okay. And can you share with the committee how Bill C-9, if passed, would affect the Canadian Muslim community?
Sure. I mean, I can give you the example of the Shia procession that I was trying to describe earlier, of Shia Muslims who participate in the Arba'in procession and walk with a green headband. And that happened just last year, and a bunch of bigots took to the internet taking photos of young children who were participating in that procession. Again, it's not a political rally. There's no political speech involved. It's purely a religious observance, and a number of bigots took to the internet posting photos of those children and saying that they are, young Hamas, or they're being trained or engaging in some kind of terrorist activity.
Thank you, Ms. Alazem.
And this is where
Thank
I
you.
get yep, no problem.
Monsieur Fortin, 2 minutes et demie.
Monsieur le Président.
Thank you, Chair. Professor Party, I'll ask you the same question I've asked many times. I believe you heard it concerning the quote stated by Adil Shakawi in October 2024 in Montreal. If you want, I'll reread it. I would like to know whether, in your opinion, that statement is allowed in Canada. You may say it's not adequate, but I would like to find out if that statement, in your opinion, is permitted. Secondly, the section of the Criminal Code, Section 319, the paragraph that provides for a valid defense based on religious exemption when we make a hate speech, should that be withdrawn from the Criminal Code? 1, is it legal, what Shakawi said? 2, should we remove the religious exemption defense?
Right. Okay, well, let me address the second question first because it's more straightforward. Those defenses that you're referring to in Section 319 are defenses to hate speech. And I don't think hate speech should be a crime. So yes, those defenses should remain. Because when you're talking about, let's just be clear, when we're talking about hate speech, we are not talking about an assault. That is a threat of violence. If it was a threat of violence, it could be prosecuted as an assault. So when we're talking about hate speech that does not include a threat of violence, then it's something else. And in my books, that speech should not be restricted. So
Merci,
the answer
mais
to your,
il nous reste
yes,
quelques secondes. Je m'excuse. Je sais que...
Thank you. I know I'm not being polite. I have a few minutes left. 2 minutes have gone by already. I understand that, in your opinion, if I say that we need to exterminate all political, liberal and conservative political organizers because I lost my election, that could be acceptable even if I'm asking them to be killed.
No, that's not true. So there's going to be a problem here where speech is not just hate speech, it's actually a threat. And what you're describing there is potentially a threat to the lives of other people.
Quand je dis, alors charge-toi des ennemis du peuple.
When I read out, deal with the enemies of the people, count them and exterminate them, don't you think that's a threat of violence?
Potentially.
No, that's it,
yes.
Mr. Party, thank you.
To be honest, I would like to see
Mr. Party, thank you.
For myself, but
Mr.
yes,
Baber, it's over to you.
Potentially, yeah.
No, mais,
Sir, what's the problem with my question? You don't like it?
No, I think your question is totally fine.
Ah,
I think you've asked it 8 times. Mr. Baber, over to you.
Mr. Party, I'll permit you to answer for my friend's benefit. The call in Montreal was for extermination of the Zionists, or supposedly a prayer for extermination of the Zionists. Do you believe that that is protected speech?
No, I in the abstract, if you say to me, if you call for the death of people, whether it's particular people or a group of people, that in my books is not okay. So I don't think you should be able to hide behind the context of that advocacy. I hope that answers your question.
Thank you. Professor Party, I'd like to talk about a few elements of the bill that haven't spoken, that have yet to be addressed today.
Yes.
The new criminal hate offense can be laid in response to any offense contrary to any act of parliament. Is that correct?
Right. Sounds like it, yep.
Yeah, so in other words, you can predicate the standalone criminal hate offense on conduct that is not necessarily criminal.
Sure, that's correct. That's possible. Yep.
So, for instance, you could suggest that non-payment of wages under the Canada Labour Code, if it is motivated by hate, could lead to a criminal charge.
Correct.
You could suggest that if someone's engaged in the suppression of votes under the Canada Elections Act, that could lead to a criminal charge.
Yes.
I find that very, very concerning.
So do I.
Especially given that the government appears to, well, in fact, seeks to lower the bar to convict of hate, and at the same time as removing the safeguard of the Attorney General. Would you recommend that we confine the application of the standalone hate offense to offenses that are truly criminal in nature?
Well, first, yes, absolutely. But second, I would recommend that you get rid of it altogether. And that's because what you are now doing, even if you limit it to criminal offenses, you are setting up two tiers of violent offenses. So let's compare two things. Let's say somebody assaults two different people, and one of them, they just choose somebody randomly on the street, or they pick somebody that they know. And in the second case, they pick somebody because of their identity. And in both cases, they do exactly the same thing. They beat them up. Okay? Both of those things are wrong. They're both offenses, and they're both equal because the amount of violence is equal. And what we're doing now is saying, well, one of those is more serious than the other one. No, they're both serious, they're both violent, they're both wrong.
If a person intimidates someone while obstructing them from entry into a religious institution or an educational institution, isn't that already illegal? Isn't that already criminal?
Yes, it is criminal if there's any kind of intimidation or violence involved, in the sense that we have criminal code offenses that can be applied there. And if those offenses do not apply because the elements are not there, then all you're talking about probably is speech, and speech should be fine.
I would think that if you're intimidating someone while obstructing them from entering a premise, that would be assault.
You'd think so. Yes, if you have absolute obstruction, if you are standing in the way and you're moving around to make sure that they can't get around you and yelling in their face, then that sounds like a criminal code offense that we already have. Yes.
Professor Party, I look at this bill overall. The government is lowering the bar for what hate speech is. It's removing the safeguard of the Attorney General consent, potentially opening folks to politically motivated prosecutions. You can lay the new hate charge on top of what is essentially civil conduct. I don't understand why this Liberal government is so obsessed with criminalizing freedom of expression.
I don't either. I wish I knew.
Thank you, Mr. Party.
You good? You have another? You good?
Yeah.
Okay. Ms. Dillon for 5 minutes.
Thank you, Mr. Chair. I'll direct my question to Ms. Al-Azam. You mentioned being perturbed by a certain line of questioning today, and you were cut off. Would you like to elaborate a little bit on that?
Certainly, I find it really concerning that the Muslim woman in the room was the one who was consistently asked to condemn Hamas and talk about terrorist actions, et cetera, et cetera. I think this proximity, this like constant association of Muslims to being proximate to terror, is part and parcel of exactly the kind of thing that I mentioned in our initial submissions, which is that we've seen for 2 decades exactly as how that line of thinking and that kind of viewing of Muslim Canadians has really impacted our not just sense of citizenship, but that we end up being over-policed and underprotected. So I really appreciate your opportunity to let me finalize that thought.
And that's. Thank you for sharing that. And you've mentioned that there's an increase in the last year in attacks, and every single day you get a certain phone call from somebody being attacked one way or the other because of their identity. Could you please talk to us a little bit the difference about what you've seen between the acts being denounced when you're being called versus what you've seen in the past?
Sorry, I don't think I fully understood the question.
So when my colleague, Ms. Latanzio, was asking you about every day you're getting a phone call, you mentioned during your testimony, of somebody being attacked on the base of their race, the way they look. Can you talk to us a little bit about the difference? Has there been a big increase in the last years that you've seen in violent acts committed against people in your community? And what kind of difference between previous attacks and these ones have you seen?
I would definitely say that there is certainly an increase. It's been an overwhelming increase for our organization to be able to address. In terms of the nature or the violence of those acts, no, unfortunately, it's not worse because we saw in in the Quebec mosque shooting, and that was how many years ago. We saw the our London family terror attack, and that was how many years ago. We saw what happened in mosques in Toronto, a caretaker at a mosque in Toronto being killed, and that was many years ago. So I can't say that they've increased in intensity, because I don't think you can increase in intensity when you're already starting line is murder. But in terms of the frequency, I'm certainly seeing an increase in frequency and an increase in regular assaults as people are just going about their days totally unprovoked, and alongside it, Islamophobic remarks or comments, etc. It certainly adds to this general phenomenon of feeling over-policed and underprotected, certainly.
And it was just mentioned before that beating up somebody is beating up somebody, and they merit, the same prosecution. That if somebody's being beaten up because they are, and somebody on the basis of the way they look, what do you have to say about that?
Certainly, the underlying maybe action is the same, but in terms of the impact that may have on a community, as a community organization that delivers community impact statements regularly in criminal sentencing matters, I can definitely assure the members of this committee that it does have real impacts. And I was in I'm a Londoner. I was in the room when the Nathaniel Veltman was sentenced. I was in the room when his actions were declared terrorism, and I was in the room a full gallery of Londoners who still are still dealing with the impacts of those actions and how it ends up impacting their sense of belonging. And it's not just Muslims. It impacts a number. We heard from a number of vulnerable community members and community groups how it impacted their sense of belonging.
Thank you.
Thank you, Ms. Milne. Thank you, Ms. Alazem. And thank you for the witnesses on this first panel. We will suspend for a couple minutes, switch over. Thank you for taking the time to do this. Okay, thank you, everyone. We are beginning our second round today that'll go till 6:30. On this panel, we have appearing in their own capacity, Mark Sandler, as an individual chair of the Alliance of Canadians Combating Anti-Semitism. Hi, Mark. From the Canadian Teachers Federation, Cassandra Hallett, Director General. From the Network of Engaged Canadian Academics, Carrie Cogan, Professor, Deirdre Butler, Associate Professor. And from the Raoul Wallenberg Center for Human Rights, Brandon Silver, Director of Policy and Projects. Again, just brief reminder that you have 5 minutes each. Just try to keep it to that. We have a little more time today, but there's a lot of you, and I think we're all eager to hear your testimony and have some interaction. There's a lot of back and forth. I'm trying to keep it dynamic between the people questioning and the witnesses, but if it gets a little out of hand, I'll ask you to direct the questions through me just to make sure that we maintain decorum and so that we can get complete answers from the witnesses today that have spent a lot of time to get here and prepared accordingly. So I'll start off in that order. Mark, you first for 5 minutes, and then Ms. Hallett, followed by Professor Kogan, and then Professor Butler, and then Brandon. Thank you.
Thank you, Mr. Chair, members of the committee, for the opportunity to address you on Bill C-9. I bring the perspective of someone who's been involved in combating anti-Semitism for 40 years, in training police and prosecutors across the country on the availability of criminal measures to combat hate, and on having appeared before this and other parliamentary committees and in the Supreme Court of Canada on multiple occasions respecting hate-motivated crimes and on the constitutionality of hate legislation. I'm currently chair of the Alliance of Canadians Combating Anti-Semitism, which is a nonpartisan coalition of over 60 community organizations, Jewish and non-Jewish, a number of which will be filing written submissions supporting the position that I outlined for you today. I've already provided the committee in writing with a detailed legal analysis of the legislation and my recommendations. So in my introductory remarks, I wish to make only 5 points. First, I support several of the components of Bill C-9 as enhancements to the existing criminal law, particularly the creation of a hate offense for those who commit conventional crimes motivated by hatred. Creation of such an offense appropriately labels offenders for the purposes of their criminal records and makes more likely the imposition of true deterrent and denunciatory sentences. I also support the new offenses of intimidation and obstruction, not because they criminalize conduct that would otherwise not be criminal, but because I know that the creation of these new offenses, having spoken to officers, will incentivize police to prioritize and address hate-motivated crimes targeting vulnerable community spaces. You will hear some people and organizations contend that these provisions violate the Charter. Similar arguments were made by those who oppose the creation of the current hate propaganda sections of the Criminal Code, and I was there. Those arguments lack merit in relation to the proposed hate offense, especially if the definition of hatred were to attract precisely the language adopted by the Supreme Court of Canada in upholding limits on freedom of expression. The intimidation and obstruction sections, if anything, more carefully protect lawful protests than existing provisions that might be used under the Criminal Code based on the specific intent required to prove each of these new offenses. Second, although the removal of the Attorney General's consent is intended to streamline hate propaganda prosecutions, which makes the proposal superficially attractive, it would be dangerous to remove that requirement altogether. The consent represents an important safeguard against vexatious and frivolous misuse of the hate propaganda provisions. The Attorney General's consent requirement should either be retained as is or retained in relation to private prosecutions only where the dangers are most acute. And as I've set out in my written materials to you, there's precedent for that very approach to be taken. Third, the existing wording of the new offense pertaining to the display of symbols raises a number of issues I've identified in my written submissions. I believe that a carefully crafted provision can address the display of terror symbols more effectively than the proposed legislation. The proposed legislation must also be amended to better protect the symbology of Hindus, Jains, and Buddhists. Fourth, there is a significant omission in the legislation, namely, there's a need for the creation of the offense of willfully promoting terror activities or the activities of a terrorist group. I explain in my written submissions why such a provision is fully compliant with the Charter based on existing jurisprudence and would focus not on which identifiable group is or is not targeted by hate speech, but on speech that supports violent terror activities unprotected under the Charter. And finally, the real issue that we cannot lose sight of is enforcement of existing laws. We are underutilizing existing criminal law measures. This committee should signal that all governments and law enforcement must work cooperatively to ensure that law enforcement utilize the tools they already have available to them, as well as any enhancements this legislation may add to address pervasive anti-Semitism in Canada and other forms of hatred. Just over a week ago, a man pled guilty in a Toronto courtroom to multiple terrorism-related offenses, for conduct that included his authorship and distribution of manifestos on behalf of a white supremacist hate group. These manifestos were cited by criminals around the world as justification for heinous crimes they committed. The manifestos advocated violence, including sabotage of critical infrastructure, murder of police officers, high-profile assassinations. The prosecutor described the manifestos to include radically anti-Semitic material and incitements to hatred against LGBTQ+ individuals, Jews, and people of color. The Supreme Court of Canada over 34 years ago recognized the need to place limits on freedom of speech to address the most virulent forms of hatred, because such speech not only marginalizes vulnerable Canadians, but attracts adherents to extremist, sometimes violent ideology. The proposed legislation, with appropriate amendments, represents one step forward in addressing the epidemic of hate crimes that threatens the safety and security of all Canadians. Thank you, Mr. Chair.
Thank you. Ms. Howlett.
Thank you. Good evening, Mr. Chair, and thank you to the committee for having me. The CTF-FCA has spoken at committee a number of times in recent years, and we always appreciate the opportunity to bring our perspective on issues that impact children, students, educators, and their families. My name is Cassandra Hallett, and I am the Executive Director of the Canadian Teachers Federation. Our organization represents over 370,000 education workers and their families, with members in every province and territory in Canada. While we represent teachers and educators from coast to coast to coast, I want to begin with the vision of the Canadian Teachers Federation: a Canada where every child has equitable access to quality public education. For us, among other things, that means every child gets to attend school without fear of intimidation, harassment, or hatred. Unfortunately, the CTF-FCA and our member organizations in every province and territory have observed a rise in the level of what we feel is hate-fueled language and protest in Canada. This language has manifested itself into a climate where students and school staff no longer feel completely safe. Educators and teachers have been targets of public pressure to stop teaching topics in provincially or territorially mandated curricula, such as climate change, the importance of racial or gender inclusion, or the value of gender equity. There has been an eruption of distrust in educators, with the public questioning whether the protection and well-being of students is a priority. This lack of trust is shocking, not only when you consider the fact that the overwhelming majority of educators enter the profession because of their passion for teaching and educating, but also because most education workers are more likely to have children of their own than workers in any other industry. The newfound skepticism education staff and students feel leaves education staff and students feeling like school is no longer the safe and protected space that many people previously believed was the norm. The issue concerned CTF-FCA members across the country so much that a resolution was passed at our annual general meeting in 2023 calling for governments across the country to create, quote, safe zones around schools that made it an offense to hold protests that target or intimidate students and/or staff on the basis of their gender identity, sexuality, race, religion, or other protected category. Children, educators, and their families deserve to go to their places of learning and their places of work with the knowledge that intimidation and hatred will not be tolerated. Bill C-9 is seeking to address intimidation felt by those attending an educational institution. The legislation even specifies daycare centres, and we commend this aspect of the legislation. Children and families deserve access to education without the prospect of feeling unwelcomed because they identify with the groups mentioned. This sense or state of safety is something that we unfortunately have taken for granted in Canada. It is saddening to note that protecting schools from discrimination needs to be explicitly outlined in legislation. But this is the moment we find ourselves in. The CTFFCA does support the intent of this part of the legislation. The issue of combating hate is very important for us and for teachers across the country. We've recently worked with the Canadian Anti-Hate Network and have shared some of their resources amongst our members because of the alarming rise in discrimination, xenophobia, anti-Semitism, Islamophobia, and gender identity-based hate all across the country. The global political climate has ushered in a new era of divisiveness and animosity. Whatever the reason for this swell in division, children should never be on the receiving end of aggressive shows of disagreement. A school needs to be a sanctuary. Many people understand that school should be a special place that's outside of the acceptable places to air your grievances or concerns. As a federal organization representative of educators, we will be the first to say we stand in line with any legislative change that makes schools or classrooms safer places to learn, play, and work. However,
Ms. Allen, you're way over 5 minutes. Do you have?
I'm
can you
sorry.
Briefly get to the end of it, and we'll
Okay,
be
I
able
am
to ask you the
almost
questions
there.
about that a little later. Yeah.
Thank you. I'll just note that we do recognize the legislation requires more review. We look to the positions of other organizations, including our partners, such as EGAL, the Black Legal Action Centre, the Canadian Muslim Public Affairs Council, or the Canadian Labour Congress, who have legitimate concerns with this legislation. And I will stop there out of time. Apologies. Thank you.
Thank you. Professors Kogan and Butler, 5 minutes total amongst you two.
Mr. Chairman, members of the committee, thank you for this opportunity to share our insights and expertise about anti-Semitism as you review Bill C-9. I'm Dr. Deidre Butler, Associate Professor of Jewish Studies at Carleton University.
Bonjour, Monsieur le Président. Je m'appelle Carrie Kogan. Je suis professeur de psychologie clinique à l'Université d'Ottawa.
Good afternoon, Chair. My name is Carrie Kogan, Professor of Clinical Psychology at the University of Ottawa. We are co-founders of the Network of Concerned Canadian Academics.
Promotes academic freedom, research excellence, and intellectual pluralism to counter anti-Semitism. Our network includes over 400 faculty members on 52 Canadian campuses.
We speak to you today as scholars. For over 3 decades, universities and colleges have been the front lines of contemporary anti-Semitism in Canada. Since October 7th, 2023, our members describe campuses where anti-Semitism continues to surge unchecked and where Jew hatred is normalized, often under the guise that this is political speech or protected by academic freedom.
NECA unequivocally affirms the urgent need to strengthen academic freedom, a right which must be exercised with academic responsibility. Critically, academic freedom cannot supersede the law, including hate speech laws. As experts on anti-Semitism, we submit examples from Canadian campuses. These illustrate the pressing need to clarify, update, and strengthen hate crime legislation to address bias, prejudice, and hate against all minoritized groups.
Too many Canadian professors and students promote violence and hatred, express support for the ideologies of designated terrorist organizations, and demand the exclusion of Zionists. Their definition of Zionist is defamatory and bears no resemblance to the actual meaning of Zionism that is an integral part of Canadian Jewish identity. Hate directed against Zionists is hate directed against 94% of Jews in Canada.
When hate is normalized, bad actors are emboldened. From hostage posters shredded and pins stuck into the photos of infant and elderly hostages, to vandalism and mischief, including shattering windows, breaking into buildings, spray painting hateful graffiti, defacing dorm rooms, and disrupting classes. These crimes are divorced from their intent and impact when they are not recognized as crimes motivated by hate.
Campus encampments displayed signs saying "No Zionists Allowed," restricting access and excluding many Jewish and other students. On November 9, 2023, the anniversary of Kristallnacht, students at several universities held protests with posters showing a foot smashing through glass to evoke the historical trauma of the Holocaust. At one university, faculty and students sheltered in offices under security, but still had to walk through a screaming crowd to attend classes. Just 2 weeks ago, an angry mob of students swarmed a small group of Jewish students who were holding a memorial for those murdered on October 7th. Across Canada, student groups on social media continue to call for the exclusion of all Zionists from campus.
The glorification of terrorism and anti-Jewish hate work together on our campuses. Consider how an encampment sign demanding resistance against the Zionist entity by any means necessary was prominently featured while a masked man proudly flaunted a Hamas bandana. To be clear, Hamas is a recognized terrorist organization. Hamas's charter calls for the obliteration of Israel and justifies the killing of Jews worldwide. Posters and social media include images of tanks, Molotov cocktails, and Kalashnikov rifles.
Campus protesters in their social media posts call for the destruction of Israel, quote, from the water to water, end quote, for global intifada, for death to Jews, death to Zionists, and display inverted red triangles, a symbol employed by Hamas to identify targets for assassination. Professors encourage and sometimes require for course credit participation and support of protests and actions that frequently amplify these terror messages and symbols. Some even celebrate October 7th massacre.
So as scholars, we support the efforts of this government in addressing rising hate in developing C9. We support the recognition of C9 of intimidation and impeding access to space. As we have illustrated, terror symbols and the promotion of terrorist ideologies are key tools for propagating hate on campuses. We support the proposal by Mark Sandler and ALCA that a separate charge of willful promotion of terrorism should be introduced, as well as the amendment to the bill dropping the requirement for evidence of hateful intent when terrorist symbols are displayed.
We speak to you today as professors who research anti-Semitism with examples from campuses across Canada. Hatred undermines the university's mission of advancing knowledge and training future Canadians. Hatred impedes the free flow of ideas that drive innovation and creativity essential to the future of Canada. When identity-based hate is allowed to flourish on campus, no one is safe. Ultimately, all of society is diminished. Thank you.
Thank you, Mr. Silver.
Honorable député, merci.
Honourable members of Parliament, thank you for giving me this opportunity to address the committee. This study on the hate crime bill is very relevant at this time when we are experiencing a real crisis of hatred.
Here over the past 5 years, with nearly 20,000 incidents reported by police. Most of these crimes target Canadians based on their race, religion, or sexual orientation. This rapid rise is underpinned by what feels like a culture of impunity surrounding incitement to hate. History has taught us that the most unspeakable of crimes begin with incitement. The Holocaust did not begin with gas chambers, it began with words, the stereotyping and dehumanization of Jews, in the same way that the killing fields of the genocide against the Tutsi in Rwanda started with radio propaganda calling them cockroaches. The Supreme Court of Canada enshrined this principle in law, affirming that Léon Mugesera, who was then living in Quebec, was responsible for participating in the genocide against the Tutsis due to his hateful speech and should be deported, even if he hadn't been in Rwanda when the killings themselves occurred. In the hate speech trilogy of Supreme Court cases in 1990, Keekstra, Taylor, and Andrews, the court affirmed the constitutionality of restrictions on hate speech. This was further enshrined and refined by courts in the subsequent decades, always holding that hate speech can be proscribed in compliance with the Canadian Charter of Rights and Freedoms. Not only are hate speech prohibitions not in breach of the Charter, they actually help protect it. Hate is an assault on the inherent dignity of the person, on the equal dignity of all people, on the right of minorities to protection from group vilifying hate, and on Canada's international treaty obligations. There is no right to use one's freedom of expression to infringe upon the rights of others. The Combating Hate Act makes a meaningful contribution to protecting Canadians and promoting human rights in the face of rising hate crime. The provisions on hate symbols and the targeting of community institutions are particularly important as a matter of principle and policy. Banning the willful promotion of hatred against an identifiable group by displaying specific Nazi or terrorist hate symbols in public addresses a leading form of incitement today. These hate symbols represent violence and are anti-democratic in nature. Such expression vilifies and excludes targeted minorities, incites harm against them, and undermines broader human rights norms. Neo-Nazism and any of the designated terrorist groups are a danger to Canadians. Their hate symbols send a clear message. A Nazi symbol tells Holocaust survivors they are not safe or equal in Canada and encourages white supremacists to act against them. The ISIS flag tells Yazidis and minority Muslim survivors of terrorist atrocities such as the Ahmadiyas and Ismailis that they are targets in Canada and encourages Islamist extremists to act against them. These are hate groups that murder, maim, and menace Canadians and seek to dismantle democracy. That is what their symbols represent. Criminalizing the intimidation or the impeding of access to a community institution associated with a minority group, such as a daycare, seniors' residence, or place of worship, protects the freedoms of vulnerable people. No Canadian, whether a Jewish toddler being dropped off at daycare, a Muslim going to mosque, or an LGBTQ plus person attending an event at their community center, should face hateful harassment and obstruction in their neighborhoods. Now, there are always legitimate legal debates surrounding any legislation being proposed. However, saying that one's constituents cannot express themselves without resorting to willfully promoting hate in Nazi or terrorist symbols or obstructing access for vulnerable groups to their crucial communal institutions says much about the nature of their intended expression. These elements of Bill C-9 are a necessary and narrowly tailored response to a massive rise in hate crimes and a reaffirmation of principles that Canadian courts have already upheld for decades. But to truly effectively combat hate crime, legislation must be followed by government leadership. The Prime Minister and his cabinet ministers should make it a habit to visit victims, offer them comfort, and to immediately and unequivocally condemn hate crimes when they occur. As well, the government should mobilize federal, provincial, and municipal law enforcement and leaders to move together in common cause. For example, the government can convene the federal, provincial, territorial meeting of ministers of justice and public safety for a special meeting on combating hate crimes and create an FPT working group that meets regularly to enhance cooperation and effective enforcement in that regard. Les aspects de loi C9 qui
The aspects of Bill C-9 that address hate propaganda and access to religious or cultural sites are essential. However, the government must show leadership beyond these measures. Thank you.
Merci, Monsieur Silver.
Thank you, Mr. Silva. Thank you, all witnesses. We will start the first round, starting with Mr. Barber, 6 minutes, and Madame Latencio, and then Mr. Fortin. As usual, you know the usual order in the second round. Mr. Barber.
I trust that you're aware of the fact that you're invited here both by the Conservatives and by the Liberals.
It's good to hear. Thank you.
I think that speaks to your expertise on the issues to be discussed today. For 35 years, we used the Supreme Court's definition of the word hatred in Kigstra, an emotion of intense and extreme nature that's clearly associated with vilification and detestation. But the Liberal definition of hatred is an emotion that involves detestation or vilification. They remove the words intense and extreme nature. And instead of being clearly associated with vilification and detestation, they just want an emotion that involves them. Am I wrong to think that the Liberal definition of hatred prescribes a significantly lower bar to convict of hate speech?
You're not wrong in the sense that I wholly support the use of the precise language that the Supreme Court of Canada used in Kigstra to define hatred, because I am concerned that the definition that currently exists arguably does lower that standard, particularly in the use of detestation or vilification as opposed to detestation and vilification, and some of the other points that you've made. I do not want any excuse for a challenge to the existing hate propaganda sections of the criminal code based upon a perceived difference in the standard set for hatred.
And you've heard some of the other witnesses today articulating a concern that the proposed definition is unconstitutional.
Well, my point is that the Supreme Court of Canada upheld the hate propaganda section of the criminal code on the basis that it set a standard for willful, it set a standard for promotion, it set a standard for hatred. And that's what made the section constitutional. So I do not want to interfere in the slightest with the standards that the Supreme Court of Canada set, which was the basis for its determination that the legislation is constitutional.
Bill C-9 removes the requirement of the Attorney General's consent for the allaying of hate speech offenses. Are you concerned that politically motivated crowns or police may initiate prosecutions that aren't appropriate? And specifically, to go further, that vexatious litigants may litigate private prosecutions for hate speech and appeal decisions that try to end or block such prosecutions?
So I am concerned, and I have expressed that concern for over 30 years, that the Attorney General's consent is a safeguard against the frivolous and vexatious use of these sensitive sections of the criminal code. That's why I've proposed either the retention of the Attorney General's consent, notwithstanding the difficulties at times in getting that consent or getting that consent in a timely way, or as an acceptable alternative that the consent be retained for privately initiated investigations, because that's the real danger, the privately laid charges.
The new standalone criminal hatred offense can be laid in response to any offense contrary to any act of Parliament. I find that to be very concerning because we may attract criminal prosecution for what is otherwise civil or quasi criminal legislation. Would you recommend that we confine the application of the hate offense to conduct that is truly criminal in nature?
Well, I definitely agree that the hate offenses should apply not to quasi-criminal offenses, but to criminal offenses. So if there is concern about the scope of the present provision, then one can either deal with it by confining hate offenses to the criminal code, or what I would suggest is specifying the acts of Parliament to which it applies.
Bill C-9 repeals Section 430, 4.1, mischief, targeting places of worship because of bias or prejudice. Going forward, hatred will be required. Doesn't that mean that it will be more difficult, or a conviction for mischief against religious property would be more limited in scope if this section was repealed, if someone was to desecrate a church or a synagogue or a mosque?
Well, let me put it this way, because in essence, I'm going to agree with you, but I'll frame it in my words. That's what lawyers do. What I would say is this, that I was an advocate when this section was created to show that the desecration of places of worship and other similar places be treated in a more serious way, and that's why this offense was created. And it need only require proof that the vandalization was based upon, was motivated by bias, prejudice, or hatred, which is a lower standard than hatred. I understand the use of hatred alone for direct offenses involving speech, but for the vandalism of religious institutions and the like, for me, this section should be retained as is. We shouldn't be making it more difficult to label the desecration of religious institutions as hate offenses.
I will take your invitation and I will phrase it in my own way, which is I believe that repealing this section will make it easier for someone to get away with desecration or mischief against a religious institution. Mr. Sandler, if a person intimidates someone as they're walking in, if they obstruct and intimidate someone as they're walking into their religious institution or their educational institution, isn't that already criminal under the criminal code? It could be mischief, it could be intimidation, it could be assault.
So as I said, so the answer is yes. What I've said is that the current proposed intimidation or obstruction sections don't make criminal conduct that is not already criminal. In my view, they send a signal to those who would be minded to commit these offenses. They assist law enforcement in giving priority to them, and they enhance sentences for it, but they do not criminalize conduct that is not already criminal.
Ms. Latanzio.
Thank you, Mr. Chair. Thank you for being here today and providing us your insights on this important piece of legislation. My question will be directed to you, Ms. Hallett. First off, I just want to, as a former school board commissioner and mom of 3 kids, I just want to, commend the work of teachers that they do on a daily basis. And I profoundly believe that education starts at a very, very young age with our kids. And I think it is important, as you stated, that we provide them with a very safe environment conducive for them to learn and to explore and to have exchange of ideas and values and thoughts. With that being said, teachers across Canada are seeing more hate and intolerance in schools. So how can Bill C9, in your opinion, reinforce the values that we see in the majority of our schools, which is safety, respect, and inclusion?
Very much. As I mentioned in my opening remarks, the Canadian Teachers Federation will really be in favor of any legislation that helps to ensure that schools can be sanctuaries where everyone, the students, of course, but also the education workers and teachers, feel safe. They're free from intimidation and harassment. And we're seeing, as has been said many times already in this room, an increasing rise in many forms of hate and violence across the country. So we do believe aspects of C9, as well as potentially other legislation, which we'll speak about at other times, could really make a difference to ensure that schools are those sanctuaries. There's international declarations calling for schools to be sanctuary spaces. We don't see that being enacted in Canada. And we really do think that much greater clarity is needed in legislation so teachers can teach provincially and territorially approved curricula free from aggressive, hateful actions, protests, etc. And so that students who may identify from a vulnerable group can be safe going to school. That's one of our biggest concerns.
And so from your perspective, how does the law, Bill C9, complement the work that teachers are already doing in order to build that inclusive spirit in our classroom, in their classrooms?
As mentioned, we appreciate the specific designation or reference to daycare centers in the legislation. There could certainly be more in the legislation related to schools, the K-12 system. Even though we recognize K-12 schooling or provincial and territorial jurisdiction, public safety is federal.
And can you provide examples of what work could be done?
We could certainly follow up with some specific language if that would be helpful.
Sure. You can submit something in writing to the committee and that would be looked at. Thank you. Over to you, Mr. Sadler. I just want to come back on the questions that were asked by my colleague, this idea of having a criminal offense and the civil component to it. And I'm very much interested in terms of, because we want to get this right. We just want to make sure that the law will have the effects that it's supposed to have. So in your opinion, I just wanted to have a clarification and a better understanding on the separation of the two and how you see it and how we can make sure that this piece of legislation would address exactly that hate and that it would be criminal in its nature.
Thank you for your question. I think what Mr. Baber was raising with me is the fact that the hate offense as currently defined applies to any criminal code offense as well as any offense under any federal statute. And so he raised a concern about whether or not any federal statute would incorporate quasi-criminal offenses that are created under other pieces of legislation, and as such undermine the purpose behind this, which is to address true crime. And I said that if there's concern about that, the way to address it is by saying that the hate offense section applies to the criminal code and specify the other offenses to which it applies, rather than leaving it open to all federal offenses that exist. Let's face it, this is going to be applicable, based upon my experience, in 99.9% cases to criminal code offenses.
Right.
So that's really where you want to strike at. Creating labeling offenses as hate offenses that are conventional offenses under the criminal code, but also have the hate motivation.
Thank you. I have no further questions.
Merci, Monsieur le Président.
Thank you, Chair. Thank you, witnesses, for being here. Thank you, Ms. Hallett, Madam Butler, and Mr. Kogan, for your position in favor of our kids in our schools. My spouse is a teacher. I have children and grandchildren, and we are always concerned by the disasters going on in our school. Thank you for the work you do. Mr. Sandler, very quickly, as you know, I don't have much time. The Criminal Code in Section 319(2) provides that any statement made in private and incites hate against an identifiable offense is committing a crime. Same for anyone inciting anti-Semitism. These two provisions prohibit inciting hatred or anti-Semitism are also associated with an exception, saying that no one could be found guilty of the section if, out of good faith, they expressed a topic or an opinion on the basis of a religious text they believe in, and they could present arguments to justify that exception or defense. In your opinion, should it be withdrawn from the criminal code or should it stay in the criminal code?
So the answer is that when we originally argued this case in the Supreme Court of Canada, the court relied upon the existence of those defenses to uphold the constitutionality of the hate propaganda sections. So I have some concerns about how the religious defense is being interpreted, because I think it's over-interpreted in a way that people think it gives a defense to religious expression when it doesn't, based upon the words "in good faith." So I'm very sympathetic to your position that that defense should be omitted, and that willful promotion of hatred should remain constitutional, notwithstanding its omission. But I'm concerned that it would reopen the constitutionality of the provision. So it's with some reluctance that I respectfully disagree with removing the section, though I'm very sympathetic to why it should be removed in your view.
En octobre 2000.
In October 2024, a year ago, the Imam Adil Shakawi made a public statement in Montreal, and I will quote what he said: "Allah, deal with these Zionist aggressors. Allah, deal with the enemies of the people of Gaza. Allah, count them all and exterminate them and spare no one." In your opinion, this statement, does it contravene the provisions of the criminal code, in your opinion?
He committed at least two offenses: the willful promotion of hatred against an identifiable group. He also committed the offense of inciting hatred likely to against an identifiable group, likely to lead to a breach of the peace. I heard that the position was taken that he was expressing a view on a religious subject. That's nonsense. The defense would not be available to him. It wasn't made in good faith, and it was simply the willful promotion of hatred. And it was no defense that he also used the term Zionist as opposed to Jews. He was using as a proxy for Jews, and frankly, it was a profound and disturbing call for the extermination of Jews, and should have been treated as such by the police.
Merci, Maître Sandler. Il reste pas beaucoup.
Thank you. I don't have much time left. Let me now move on to something. Overall, in C9, there are lots of topics addressed and that I agree with, but are already in the criminal code. You discussed this with other colleagues who asked questions before me. Now, adopting a bill that duplicates what is already in the criminal code, is this not counterproductive, as it may be opening doors to interpretations that were not there before? Because we know that if we prohibit specifically something else, it may be because we are allowing something else. So don't you think this is counterproductive, this approach in legislation?
I don't, but I have to look at each of the sections. So when you look at the hate offense, for example, that is something that is being added that is new because it is labeling the offense in a different way than it's currently labeled. And by the way, it's completely consistent with even the more limited use of the criminal law in the United States. They have hate offenses in the same way as is being proposed here. The reason why the labeling is important is because a lot of the hate mongers are repeat offenders, and it's important that the criminal record labels their prior offenses in a way that prosecutors and police know that the prior offenses were hate motivated. That is not always apparent from looking at the record, and it provides for enhanced penalties if the Crown proceeds by indictment. So for me, that's not duplication. In terms of the intimidation and obstruction, because I know your time is limited, I'll answer very quickly to say it is already criminalized by other offenses. For me, the message I'm getting from police is that if we specifically deal with it in the context of access to places of worship and other places, that will give greater priority and attentiveness on the part of the police to utilizing these provisions effectively. So I recognize the duplication. I would normally agree with you that we don't simply duplicate for the sake of duplication, but for me, I think there's some important messaging through the use of those provisions.
Thank you.
Merci.
Thank you, Mr. Sandler. We'll do a complete second round, starting with Mr. Lawton, House Father, Fortin Gunn, and then Chang. The third round, I'll do some slicing and dicing to come up with something reasonable. So I'll get back to everyone on the complex math involved. But Mr. Lawton, please begin.
Thank you. Mr. Silver, you had alluded to the importance of political leadership, and I actually agree that in the context of C9, we have to look at the broader context of hate and its origins. You would, I'm assuming, be aware in August there was an open letter signed by several Liberal members of Parliament condemning the rise of anti-Semitism. What do you make of the fact that only 31 Liberal MPs, a very slim minority, signed that letter?
The engagement by members of parliament from across all party lines in combating hate is something that's appreciated by the center I represent, and we take an all-party approach to our commentary on matters before the House.
Sorry, I'm not sure if you heard the question, sir. I asked, what do you think of the fact that only 32, I apologize, Liberal members of Parliament signed a letter denouncing the rise in anti-Semitism in August?
I would imagine that any member of the House, I would trust that any member of the House, given the opportunity to comment, would condemn anti-Semitism, and I, in my own experience engaging with members of the House, see that to be the case, that this is something that should be above partisan politics, the condemnation of anti-Semitism, and the strong support from all parties in the House on the matter.
Wonderful. So not signing a declaration condemning anti-Semitism is a bit of a problem. I'm glad we got there, Mr. Silver. Your organization's founder, Erwin Kotler, had actually advised Mr. Anthony Housefather, a Liberal member of Parliament, to leave the Liberal caucus over anti-Semitism at the Liberal Party. Do you agree with Mr. Kotler's advice?
I'm here representing the Raoul Wallenberg Center for Human Rights. You can feel free, you might want to consider addressing any questions about Professor Kotler's views on any particular electoral matter to him directly. I'd be pleased to comment on any aspects of Bill C9.
But you did mention political leadership as being important. Do you think there has been leadership from the Liberal Party on anti-Semitism in the last 2 years?
So the references to political leadership were with regard to what tangible...
Sorry, I appreciate that. Do you believe there has been leadership from the Liberal Party of Canada in condemning anti-Semitism in the last 2 years? Yes or no?
So what we call for here is...
That is a yes or no question, Mr. Silver. Are you declining to answer?
In condemning anti-Semitism.
Okay, I reclaim my time, sir, if you're not going to answer. I'd like to turn to you, Ms. Hallett. You mentioned protecting teachers against hate. So your concerns on Bill C-9, your engagement on C-9, regards to what you think is directed or what you're identifying as being directed at teachers, correct?
Partially correct. Our concern is for everyone in the public school system, teachers, students, education workers. We're deeply troubled by rise in hate against students from vulnerable groups, as well as educators from vulnerable groups.
Have you read the Government of Canada report, Anti-Semitism in Ontario's K-12 Schools?
I have not read that specific report. However, I've read many reports on increasing violence in schools and been part of many resources to create safe, inclusive spaces for our schools.
One of the takeaways from the reports is that of the thousands of incidents, a great many of them are anti-Semitic incidents, 1 in 6 anti-Semitic incidents involve teachers or school-sanctioned activities. Does that concern you, that teachers and schools are actually involved in perpetuating hate against students?
Any perpetuation of hate is a concern. I would not comment more on a report I haven't read and one statistic that's been pulled out of context for me, but I can assure you that the vast majority of educators across this country are doing their level best to create safe, inclusive environments for all of the students in their care, and they deserve the same as educators.
What do you believe should be available to students and families dealing with anti-Semitism when the person of authority, the teacher or the school, through a sanctioned activity, is responsible for it? That's what this report gets to, and I do hope you'll take a look at it after.
And I will. I won't speak specifically on Ontario matters, as we are a pan-Canadian federation representing the teachers' unions and educators across the entire country. But I can again assure you, as an educator myself, that in every province and territory, there are mechanisms in the teaching profession, in public schools, just as you find in other professions. If someone is out of bounds, so to say, if their conduct is inappropriate, if they, as the example you're citing, are inciting hate, then there are mechanisms for follow-up, appropriate channels for addressing that, for complaint, for discipline. Please don't think that that's any different than another issue. There's absolutely recourse if someone is conducting themselves inappropriately. Thank you.
Thank you, Ms. Hallett. Mr. Housefather, for 5 minutes.
Thank you, Mr. Chair, and thank you so much to the witnesses. I note that 2 of the different witnesses, Mr. Sandler and Mr. Kogan and Dr. Butler, appeared before our committee last year on the anti-Semitism study, and that C-9 puts into effect many of the recommendations from the Justice Committee on the anti-Semitism study. I would also note that the letter that was referred to by my colleague, Mr. Lawton, actually endorsed each and every one of the recommendations from the anti-Semitism study, some of which Mr. Lawton doesn't endorse. So he would not have signed that letter. And I don't think it was a simple condemnation of anti-Semitism. It was actually a detailed request to government to implement measures, many of which are reflected in this law, C-9. So let me ask, Mr. Silver, do you agree that regardless of whether some of these measures in C-9 would essentially reformulate certain elements in the criminal code, that they send an important message to police and to prosecutors and send an important message to provinces and municipalities that these are important to the federal government within our sphere of jurisdiction, that we want them to act, because a lot of the complaints have been that they are not acting. For example, the intimidation and obstruction offenses. Do you feel that these intimidation and obstruction offenses will assist police in actually charging people who are blocking access to buildings?
Fellow witness Mark Sandler gave a very compelling and comprehensive response to some of those matters, which I would indeed echo. The signaling, from a deterrent standpoint to those in breach of the law, what it adds to their record, and also the signal it sends to law enforcement and to partners at every level of government that this is a matter that should be a priority, that there is a requirement for enhanced enforcement that has been a large part of the problem until now, and which is why my reference to political leadership also with some specific recommendations about the FPT, federal, provincial, territorial meetings by the relevant ministers and their counterparts at every levels of government have not been sufficiently utilized for hate speech matters, and whether for questions of enhancing enforcement and coordination, a specialized working group could be created after a meeting. And surrounding the questions of Attorney General consent, I mean, it's presented as a sort of zero-sum game between the current, clogged system where there's not enough movement on approvals and removing it altogether. But perhaps the FPT can also be a forum for enhanced cooperation between levels of government on approvals of prosecutions by the AG. I think there's other alternatives that can be offered to ameliorate the situation in terms of providing the relevant consent at the federal level and in partnership with provinces, territories, and even municipally.
And you don't agree that the careful line that has to be drawn between the interplay of Section 2 and Section 1 of the Charter to limit freedom of expression in certain contexts, I think you expressed it very well, is violated by the terms right now that are, or the clauses right now that are in the bill?
And I would add that, there are other relevant sections of the Charter as well. Section 15 on equality, Section 27 on multiculturalism. There are multiple Charter values that come into play, and quite consistent Supreme Court decisions throughout several decades that uphold that narrowly tailored restrictions regarding hate speech actually align with not only Section 1 being a valid restriction, but also uphold the other sections of the Charter that espouse core Canadian values. And to your earlier question on, obstruction, on hate symbolism, there is an additional component of very specific proscribed symbolism. That is new and it's important. And, I had emphasized in my remarks why these symbols incite hate, why they are anti-democratic. And that is an important addition to existing criminal restrictions.
Mr. Chair, do I have any time left?
35 seconds. Often, Brandon can answer.
My last question is to Mr. Sandler. Mr. Sandler, you had talked about, you agree, Mr. Sandler, that C9 should proceed. You agree that it's important, and you agree that law enforcement will get a good lesson from C9 to actually enforce provisions that previously we all agree they have not been enforcing, perhaps the new ones and old ones. Can I ask you about removing the words of hateful intent as well, in terms of the limitations on flying the terror symbols? What exactly would you propose be changed in terms of what would you remove exactly?
Mr. Sant, very briefly, or you can submit a written.
Very briefly, if you see my written submissions, I've set out a series of proposals that would more clearly tie the symbols to terror activities and would be a freestanding offense that wouldn't require proof of all of the elements of willful promotion of hatred. So I've set that out in more detail in my written submissions, Mr. Housefather. Thank you so much.
Thank you both. Monsieur Fortin, comme d'habitude, 2 minutes et demie.
Merci, Monsieur le Président.
Thank you, Chair. Mr. Sandler, I understood from your testimony that you support C9. That's good. I'm not sure I understood your position on the fact that the prior authorization of the Attorney General to prosecute hate crimes. C9 is proposing to remove that requirement. Do you think it's a good idea, or should we maintain the prior consent of the Attorney General?
Well, I've said that I support C9 with the qualifications that are set out in my written submissions. One of the qualifications is I do not support the removal of the Attorney General's consent altogether. So I see two alternatives. One is that you retain the Attorney General's consent as a safety measure against the misuse of these sections. The alternative is that you retain it at least in relation to private prosecutions, because that's where the real mischief will take place.
Merci, Professor Sandler. Professor Butler.
Thank you, Mr. Sandler. Professor Butler, I would like to ask you the same question. Sorry, I made a mistake. It's Mr. Silva. Mr. Silva, I'll ask you the same question. In your opinion, the provisions of the criminal code that require prior authorization from the Attorney General before prosecution, should we uphold them or remove them as C9 proposes. Thank you, Mr. Faulkner. I share Mr. Sandler's opinion. I propose that there may be other solutions as well. We may create a more efficient system. The consent of the Attorney General may be more rapid, more efficient. We don't need to remove that consent to attain our objective. We could keep the consent, but come up with a more efficient process, an internal process, and a process in collaboration with other levels of government, the provinces, the territories, municipalities, and so on. I'm trying to speak French. Thank you.
Monsieur le député Gunn.
Mr. Gunn, 5 minutes.
Mr. Sandler, if the bill C9 isn't amended significantly, if the provisions remain as far as the AG, removing the requirement for the AG consent and as well as the watered-down definition of hate, could you support this bill in its current form?
The simple answer is no. I want to see, I need to see movement on the Attorney General's consent, and I need to see movement on the definition of hatred.
Do you believe that you made some other points? I can't remember which question you were responding to, but you were talking about. I believe it maybe was a preacher in Montreal that you believed had violated the law as they are written. Do you believe that the laws in Canada, particularly those that pertain to the incitement of violence, are enforced equally and consistently across the country today?
Boy, that's a question that could occupy an hour of time. The bottom line is that I work with law enforcement right across the country. I do not believe that the current measures are enforced in the same way in every jurisdiction. Sometimes the laws are underutilized in some jurisdictions. That's not the case in other jurisdictions. So, no, I don't see an even application of the law.
Why do you think that is? Or why is that?
Well, I've set out in a discussion paper that was presented at the National Forum on Anti-Semitism a series of issues that I think have to be addressed. The first is that police officers have to be acquainted with all of the legal measures that are available to them to combat hate, and sometimes police officers are unaware of those provisions that exist. The second is police officers have to understand what forms of hatred exist in the context of anti-Semitism, what contemporary anti-Semitism looks like. They've got to understand what it means in order to apply the law effectively. And third, they have to be supported by whether it's municipal police service boards or municipalities, if they're municipal police forces. In other words, they don't direct the day-to-day decisions made by police, but they have to demonstrate a zero tolerance for anti-Semitism and other forms of hatred. They have to create policies on policing that should be implemented by the police force, and I see some of that not taking place right across the land.
With the concerns that you raised earlier that you then connected to not being able to support the bill in its current form, if the bill does pass in its current form without those modifications, what do you think are the what are the largest or most likely potentials for abuse, or the most worrisome potential elements for abuse?
Well, the two that concern me the most, the first is that I don't want to see in this highly politicized environment that we live in, private prosecutions being laid, for example, against Zionists just for being Zionists. And that's what we're going to see, efforts to weaponize the sections of the criminal code. And that could take place regardless of whether this legislation passes or not. But that's why the Attorney General's consent or the proxy that I've suggested for it is of concern to me. And the second is that although the courts may interpret the definition of hatred as being synonymous with the Supreme Court of Canada's decision, I don't want the risk of relitigating the existing sections of the criminal code and potentially coming to a different result. So those are two of the things that I would identify.
And Just one final question that I had for you. There's been a lot of talk about some concerns surrounding the erosion of free speech and free expression in the United Kingdom and some of the laws there. It's not an area that I'm an expert in. From your opinion, is it justifiable to have concerns about the erosion of free speech and free expression and going down the road of essentially jailing people for making social media posts that some find distasteful or hurtful or even hateful?
Well, the answer is that I've proposed a new section, which is willful promotion of terror activity, because I don't like the looseness in the language that exists in the United Kingdom over glorification of terrorism, which I think is prone to the concerns that you've expressed. So for me, that's why I look at the terrorism sections that currently exist under the criminal code, and they're a hodgepodge, very difficult to apply for law enforcement, and law enforcement express concerns about it. And that's why I've crafted a potential section that's very narrowly crafted, that draws upon existing jurisprudence and recognizes that we do not protect under freedom of speech guarantees under the Charter the willful promotion of terror, in other words, violent activity. So I am concerned that we not go the route that the United Kingdom has taken. I don't think this legislation is doing that, and I certainly don't think that my proposed new offense would do that either.
Thank you. Thank you both. MP Chang for 5 minutes.
Thank you, Chair. Mr. Silver, do you think it's fair to say that freedom of religion and freedom from hate depend on each other, that both are essential to a safe and inclusive Canada?
Yes, and that's recognized in the Charter itself and in the precedent of the Supreme Court on hate speech provisions that were, as my fellow witness, Mr. Sandler, referred to, have been litigated in the past. They need not be relitigated. Protecting vulnerable groups from group vilifying hate ensures their equal participation in society, and anything less is an erosion of democratic norms that allow the fulsome participation of every Canadian, regardless of their background, in public discourse and in living their lives freely.
Thank you. Your organization has long championed for the protection of human rights and fight against anti-Semitism around the world. How does Bill C-9 advance Canada's broader leadership in these areas?
Well, there was a reference as well in my remarks to Canada's international obligations, and while the focus has been largely domestic and quite understandably so in terms of existing precedent and policy, there's also a corpus of international law that this dovetails quite effectively with, mandating the upholding of equality protections and also validating prohibitions on group vilifying hate. So this also brings this legislation, and particularly the components that I referenced in my remarks, bring Canada's legislation as well in line with international standards. This is something that has, again, been decided domestically by the Supreme Court, and also there is a corpus of international law and a number of international cases that uphold the legality of these provisions.
Thank you. This bill focuses on protecting access to religious and cultural spaces from hate-motivated interference. Why is this kind of protection especially important in today's climate?
Well, as I referenced in the opening of my remarks, in the last 5 years alone, there's been an increase to 20,000 hate crimes. There's an exponential growth, and there needs to be a concerted effort to address it. Now, this legislation is certainly not a panacea. It won't provide all the answers, but I think the important signaling that it does, the deterrence effect that it may have on would-be criminals, and the prioritization it would encourage by law enforcement makes a meaningful impact in trying to tackle what is indeed a crisis, and not doing anything would be far worse.
Thank you very much. And my next question is to Mr. Hollett. From your perspective, how does this legislation like this complement the effort teachers are already making to create inclusive, welcoming learning environment in Canadian schools?
Thank you for the question. I believe I touched on this earlier insofar as the legislation, as we've reviewed, really only focuses on daycare centers in terms of a specific education focus. So whilst the Canadian Teachers Federation welcomes that aspect of the legislation, there's not a lot in it that's specific to the K-12 school system from our perspective. Does not mean it would be unhelpful, but we are really eager to see much more being done at all levels of government to ensure that schools are safe for, as I've said before, students and all of the education workers in the schools. So it's not counter to making schools safe necessarily, but it doesn't go very far in terms of K-12 schools.
Thank you. My last question would be, how can this legislation empower our communities to respond more effectively when hate incident occurs, not just through justice system, but through education and prevention?
You know, a piece of legislation, again, if I speak on behalf of educators, will only go so far. But however, if we can make strides in Canadian society to condemn hate in all its forms, that will be something that has a trickle-down effect for our educators and for their students, because as a society, we will be improving in terms of ensuring that we know hate in all its forms, whether it is anti-Semitism, anti-2S LGBTQ rhetoric, et cetera, is not acceptable. So certainly legislation that promotes safety and freedom could be helpful, but the specifics of how C9 would help in K-12 schools, I think it would take some time, respectfully, to see how that would bear out.
Thank you.
Thank you.
Thank you. We'll have about another 10 minutes of questions, starting with Mr. Baber, then Mr. Chang, 4 minutes each, and then Monsieur Fortin to close things all off with 2 minutes.
Mr. Sandler, I appreciate my friend MP Gunn's exchange with you on the equal application of the rule of law. Every Sunday in my riding in North York, a bunch of thugs show up in kafiyas and they scream for intifada. The basic translation of the word intifada is violent resistance, and yet no arrests ensue. Let me ask you something. Do you believe that calling for intifada on a Canadian street is incitement to violence?
I believe it definitely can be. The only reason I put a qualifier on it is because I always, as part of my training, instruct police to look at all of the circumstances and all of the words said in determining whether the requisite intent exists. But it is definitely capable of that, especially when coupled with other language that is clearly either genocidal or hate-filled.
If they have a character dressed and role-playing Yahya Sinwar, the mastermind of October 7th, would you call for the chance for intifada, incitement to violence?
Well, I've taken the position that some of the demonstrations that you're describing did cross the line into hate speech.
And yet no arrest from the Toronto police?
It's been very challenging to address situations where they do not involve kind of traditional forms of hate. So when you're doing the intersection of anti-Zionism and anti-Semitism, there has to be a better understanding of what's being said and when it crosses the threshold into hate. So when people are chanting all Zionists are evil, genocidal, and racist, regardless, without distinction, that crosses into hate speech. That's very different than criticizing Israel, its conduct, its policies, its government, and the like. And those distinctions have to be better understood.
Mr. Sandler, it's okay for us to politely disagree. All I ask is for equal application of the rule of law, something that regretfully we're not seeing in this context, and we're hearing deafening silence from my friends the Liberals across the aisle on this. And this bill does not do anything to address any of that, because all of that is already contrary to the criminal code. I heard you say in your opening remarks that you're disappointed that willful promotion of terrorism did not make it into this bill. I'd like to take an opportunity to remind you that the former Conservative government passed promotion of terrorism into the criminal code as a criminal offense, and that in 2017, the Liberal government under Justin Trudeau diluted that law, and in fact repealed some portions of that law. leading it to remain as only a counseling terrorism offense. Please talk to us a little bit about willful promotion of terrorism. What do you like to see added, and do you believe it will survive constitutional scrutiny if framed correctly?
Well, I have no doubt that it'll survive constitutional scrutiny because I've drafted the legislation for the consideration of this committee. It's contained in my written submissions, and I've drawn upon words that have already been constitutionally protected: willful promotion of, and then instead of hatred against an identifiable group, dealing with terror activities or the activities of a terror group, both of which, terror activities and a terrorist group, are defined already under the criminal code. So for me, there can be no constitutional protection for the willful promotion of terror activities or the activities of a prohibited group under the criminal code. So you can look to my written submissions for some of the language. For me, this would solve a number of the issues that currently exist.
Like what?
For example, when there's a fight about whether or not it's willful promotion against an identifiable group, namely Jews or Israelis, as opposed to whether it's political speech against Zionism, that shouldn't be the focus in all instances. The focus should be on whether you're promoting terror activities, and this would put the focus where it belongs for some of these cases.
Thank you. Thank you, Mr. Sandler. Ms. Dillon for 4 minutes.
My questions will be directed to Mr. Silver. First of all, thank you so much for your incredible testimony today. You actually got to the bottom of something that hasn't been mentioned thus far, which is words. It takes words. It takes hateful literature, propaganda to start something. And you gave the examples of the Holocaust and the Rwandan genocide. This was very, very important to the work we're doing here today. Not 10, not 15 members of the Jewish community, but 6 million were subjected to the Holocaust. This all started with words, and thank you so much for pointing that out today here. And during the previous panel, I was actually having the same thoughts as you, that symbols are used to emphasize these things. It's the Nazi symbol, the Confederate flag. These were symbols used during the convoy right here in Ottawa. The Confederate flag, the Canadian flag being hung upside down, the Nazi sign painted on the Canadian flag, Conservative members of Parliament serving coffee and donuts to these people. Everything that happened was to intimidate and harass citizens. It was an attack on democracy. Can you please talk to us a little bit more about words and propaganda and hateful literature, as you were mentioning in your opening statement? Thank you.
Thank you, MP Dillon, and without opining on any particular, instance within Canada, the legislation itself is incredibly important in identifying specific symbols that are used in the willful promotion of hatred. It's a very narrowly tailored and an elegant piece of legislation that tackles a growing problem. We see that the incitement that you so eloquently referenced in your remarks that underpin attacks against vulnerable minorities, these hate rallies that Député Fortin referenced, oftentimes they're accompanied by very specific symbols that have a specific context and with a specific and willful goal, and that is to intimidate vulnerable minorities and to ensure that some Canadians do not have equal access to their places of worship, to their schools, to their community centers, that they cannot live their lives fully and equally as Canadians. And these symbols are a part of that process, and this legislation makes an important point of pointing that out.
So much for that. And I think I'm running out of time. Quickly, there was something said about assaulting somebody because of how they look. And the other thing is, there are Holocaust deniers, and they use that as freedom of speech. Brian Mulroney said something very interesting in 2023. Firewalls were thrown up in the wake of the Holocaust, and this bonfire was reduced to flickering embers, but those firewalls, weakened by the passage of time and willful neglect, have been breached. Cloaked in the armor of free speech, fueled by hate, and stoked by the oxygen of the internet and social media, those fires now burn out of control. This applies in this context, but do you believe that this applies to other contexts where there are minorities, there are people from the LGBTQ community? Do you see these fires being stoked once again, and see the slow erosion of civil liberties and all these rights of those who are vulnerable being violated? Thank you so much.
We won't have time for an answer, Mr. Silver.
If you can please give a written,
and that would be acceptable to us. So.
To give a written answer. Thank
Absolutely. you. Monsieur Fortin, 2 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Madam Halat, I have only 2 minutes, but I will give them to you. Please tell us about the impact against hate symbols on our teachers and children in schools, and if possible, could you distinguish between the types of symbols we are talking about? Is it symbols identifying a criminal organization, or symbols identifying a terrorist organization, or any other types of symbols? In 2 minutes, please tell us the impact these symbols have on children and teachers in your schools.
Merci beaucoup.
Thank you very much. Unfortunately, throughout the country, we are seeing a rise in violence and assaults in our schools, especially at elementary level. In our research throughout Canada, we have seen that there are indeed symbols influenced by social media, and this has a negative impact on our kids. To the extent that some don't feel comfortable and safe in schools. Others feel that they may become more aggressive because of the symbols. Do you have specific examples of the types of symbols? For example, we know that there were some T-shirts, Hamas flags. Let me think of the example in New Brunswick. We have symbols like cards that were sent by post against the LGBTQ community. It was clearly against that community, and that had a very negative impact on our children. And there are other examples throughout the country that we can share. Thank you very much. Thank you. Unfortunately, the time is up.
Sure. Yeah, but I just want to let's thank the witnesses, and thank you for this was very helpful to the committee, and indeed this will probably translate into our views on the legislation. So I want to take the chance from the chair's position to thank all of you for that testimony today.
Before the witnesses are dismissed, Mr. Chair, I just wanted to say I ran out of time before I could get to Professors Butler and Kogan, but I sensed they had a response to the government's report on anti-Semitism in Ontario schools, and I just wanted to ask if we could allow them to provide a written submission on anything they wish to share on that to the committee.
Absolutely.
Okay. Thank you very much.
Thank you.
Sorry, I wanted to get to you, but I ran out of time. Thank you.
Thank you.
And on that, I wish everyone a great Friday and a great weekend. Go Jays.